Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people, and people misspelled P-E-O-O-P-L-E?
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
Welcome back to the Court of Public Opinion. I am the Recovery Addict. My mic is a little bit quiet today. Test one. That's better. Okay. Fixed it. We are back. We have the afternoon to watch 2 days of court. We're going to be here for about 3 hours and 40 minutes, a little longer if we drag this out a little bit. So knowing that the weekend is coming, knowing that your time is precious, if you want your weekend, we're going to get this kicked off right away. But first, I need somebody to rat out the person who won the internet, because I missed it. Greener says it was me. It was me. Greeners, I believe you. I believe it was you. Congratulations, Greeners. The internet is all yours again. You're going to do great. You're going to do great, Greeners. Thank you very much, my friend, for owning up. For owning up to your wrongdoing. Sorry, chat on screen now. Greener says the winner. Congratulations. And it looks like Kim R gifted 10 memberships right before we came in as well. I just missed that. Hopefully all wonderful people received those. I'm sure they did, because there's nothing but wonderful people here. But congratulations, and thank you, Kim, for your generous donation of gifted membership. 8 out of 10 were wonderful people, says Greeners. Those other two we just won't talk about. Just won't talk about them. All right, here's where we are. In court, we've cut out all the long bits. Well, the court did. They cut out all the long bits that we didn't want to hear. And so we're going to just kick it off with this Zoom court, which has pretty good audio so far. I'm pretty impressed. I'm actually really impressed. But let's kick it off right now. Judge is just getting online.
All right,
there he
counsel,
is.
are we ready to do the jury yet?
This is a jury trial. The defendant on the far left in the top right-hand picture.
We just had a chance to review the interview video. There was one more requested redaction. It'll take me not too long to make, Your Honor. If you would like me to make it now, that way we're ready to just keep going, or we can take a short recess, and I can probably finish up in 10 minutes. It's not going to be with our first witness, though. I just don't know, as far as keeping everything flowing smoothly, what the court's preference to do.
You don't have anyone that can make it for you while we're...
Unfortunately, I'm not the only one with software.
Are you going to be doing the opening and directing on the witnesses?
I'm going to be doing opening, first witness. Mr. Hernandez is going to do the second witness. And then I'll be doing the third with the video.
All right, so you said you have it done and completely done and redacted in 15 minutes?
Yes, sir. I think 15 minutes should give me enough time to have it redacted.
Any other issues before we go off the record?
Your Honor, I'm sorry, Stevens, I did want to bring just to the court's attention, in light of the motion in limine that was filed by Mr. Stevens, the court granting it, we just wanted to be certain, clear that we intend on giving context to why law enforcement showed up at Mr. Young's home. And that's because they were following up leads on a burglary out of Smith County. He was not a suspect, but rather was being contacted as a potential witness to that burglary. And for that reason alone, we are referencing the deputies coming to that home. Fact that is, they actually found 10 of those gold coins, which were allegedly taken in that burglary, on the property. And then the Smith County deputies requested a search warrant. We're giving context to how the search warrant came to be
10
and
gold
how
coins?
the firearms were located as a result of that search warrant. In light of the court's motion in limine order, we just want to make sure that everybody's on the same page, that it was our intention all along He was never a suspect. He was not charged with anything as a result of that Smith County case. But we just don't believe that it would make sense to all of a sudden just pop 2 deputies from Smith County and Van Zandt County and not give it a reason.
Does the state intend to disclose who was arrested as a result of that investigation?
Your Honor, we do intend to disclose the fact that a Russell Melton was the target of that investigation. I don't know what the final disposition of Russell Melton was, but I know he was the target of the investigation.
The state will not be leaving the jury with the inference that this defendant was the target of that investigation or was in any way whatsoever connected to that investigation other than it being at his home or a residence that he was residing at?
His home, but that's correct, Your Honor.
Mr. Stevens? I don't really check. Okay, very well. All right, so I'm going to have Deputy Martinez notify the jury that we'll begin at 1:20.
Okay, thank you.
Russell Welton.
Get to work on this right now.
All right,
Russell Welton.
Recess till 1:20.
Pled guilty to the theft of $440,000 worth of gold coins as part of that burglary. $440,000 worth of gold coins. That was back in December, on December 14th of 2020.
I think so, okay. Yeah.
Out of Tyler, Texas.
Awesome. All right, amen.
$440,000 worth of gold coins, a GMC Denali, guns, and a HP laptop were stolen in a home burglary. That was like a score. That was $500,000. $500,000.
Ready?
Yes, sir. We're all good. Double checked it, so.
$20 pesos.
Okay. You can go this way.
One of the occupants of the car said the coins were given them by a homeless person.
Wow. Maybe somebody else. Okay.
Wow.
And Josh was just right across the hall.
Counsel, we ready to proceed? All right, so I'll rise to the jury.
Your Honor, will we be swearing in the witnesses then before
the jury?
Are you asking about voting in the room?
Well,
How will we? Yeah, we'll do all that for the jury.
okay.
All right, you may be seated. All right, good morning. Good morning. Good afternoon, ladies and gentlemen of the jury. Rarely do I say that because usually we get started in the morning. We are now on record cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. And as I told you yesterday, what we heard do this morning is we would present the indictment to the defendant, and then we'll begin with opening statements and the first witness. So at this time, if Mr. Young, if you'll please rise. Mr. Hartwell, if you will present the indictment to Mr. Young.
Yes, sir. In the name and by the authority of the state of Texas, the grand jury for the county of Van Zandt, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2021 of the 294th Judicial District Court for said county, upon their oaths present in and to said court at said term that Reginald Hoyt Young II, hereinafter style defendant,
it's okay,
on or about November 25th, 2020, and before the presentment of this indictment in the county and state aforesaid, did then and there intentionally or knowingly possess a short barrel firearm, to wit, an Eastern Arms 16 gauge shotgun, against the peace and dignity of the state, signed foreman of the grand jury.
Thank you, Mr. Harwell. And Mr. Young, how do you enter a plea?
Not guilty.
Not guilty? All right, thank you. You may be seated. All right, is there a request for the rule to be invoked at this time?
Yes, Your Honor, we invoke the rule.
All right, if all the witnesses will be brought here before the bench. All right, witnesses, the rule has been invoked, and in just a moment, you're going to be ordered to leave the courtroom and not re-enter unless instructed to do so by the court or the bailiff. While you're under the rule, you're not to discuss the case or your testimony with any other witnesses or anyone else except the attorneys. You're not to read any report of or comment on the testimony or evidence in this case. Any witness violating this instruction is subject to being held in contempt of court. Do you all understand the rule? All right, if you'll step outside and then wait for your name to be called. All right, is the state ready for its opening statement?
Yes, Your Honor. Thank you.
Do you need the podium?
Yes, please. Thank you.
Looks like I'm going to need to move.
May it please the court. Mr. Stevens. Good afternoon, ladies and gentlemen. Been practicing that one all day. I want to thank you all for returning today. I know there's a lot going on right now. I know there's a lot happening in your lives. So we truly appreciate your time and dedication to seeing that the justice system has the opportunity to work. To be really kind of blunt about this case, it's fairly straightforward. On November 25th, you'll hear evidence that deputies with Smith County Sheriff's Office was investigating another incident that happened in Smith County. You'll hear that Mr. Young was not the subject of that investigation. In fact, the subject of that investigation was a man by the name of Russell Melton. However, during the course of their investigation, the deputies with Smith County were led to the property that Mr. Young resided on. You'll hear that they found some evidence from that Smith County incident on the property. And as follow-up, they got a search warrant and searched the property, where they found a sawed-off shotgun. You'll hear evidence that Mr. Young admitted that he, in fact, did have possession of that sawed-off shotgun. Ladies and gentlemen, by the end of the trial today, tomorrow, we expect that the evidence is going to show that, in fact, on the property in Van Zandt County, where Mr. Young was staying, there was a prohibited weapon, 16 gauge shotgun that was sawed off. And I believe the evidence is going to show to you that Mr. Young was in possession of that shotgun. At the end of this trial, we're going to ask you to find Mr. Young guilty of this offense. Thank you.
Pretty straightforward.
Thank you, Mr. Harwell. Mr. Stevens, does the defense wish to have an opening statement at this time, or do you
We would reserve, Your Honor.
want to defer until the state has rested its case?
Yes, sir.
All right, Deputy Martinez, if you'll remove the podium.
One of the shortest openings ever. It's all about who had the sawed-off shotgun.
Who does the state call as its first witness?
Your Honor, state calls Investigator Tim McDonald.
Tim McDonald.
The prosecutor's like, did I stutter? Yes, Tim McDonald, come on in.
All right, Mr. McDonald, if you'll raise your right hand on the patient oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, Your Honor. Please watch your step. That chair does move. So move it around. Deputy Martinez will adjust the microphone for you.
And the
That's
camera.
as comfortable as you can in an old wooden chair. During your testimony, you don't have to lean into the microphone, but you do have to project, speak loud enough for it to pick you up so that everyone in the courtroom can hear what you have to say. Allow the attorneys to finish questions fully before you give an answer. Of course, my court reporter, Ms. Grisham, is trying to take down a transcript, so it becomes very difficult if we talk at the same time. If an objection is lodged, just stop testifying. The court will rule on that, and it may happen that an emergency vehicle or a loud truck will pass by. If that happens while they're asking questions, they're going to stop, or if you're testifying, stop. Let that sign pass so that we all hear what you have to say. Okay?
Yes, Your Honor.
All right.
Thank you,
Sir,
sir.
well.
Good afternoon, Investigator McDonald. Can you please start by introducing yourself to the jury and spell your last name for the court reporter?
Absolutely. Tim McDonald, TIMMCDONALD. And I'm Tim McDonald, an investigator with Smith County Sheriff's Office.
And Investigator McDonald, how long have you been an investigator with Smith County?
Right at about 10 years.
And has that been continuous?
Yes, it has.
So you would have been an investigator with Smith County in 2020?
That's correct.
Did you have any other law enforcement jobs or roles other than investigator with Smith County?
I did. I was a patrol deputy for approximately a year and a half prior to becoming an investigator.
And can you tell me a little bit about how you become a deputy?
Absolutely. Initially, it began with Police Academy. That I graduated from East Texas Police Academy with Kilgore College. And, I began my career with the Jacksonville Police Department, and I served there until January of 2013, and I was a patrol deputy for Smith County Sheriff's Office. And I was promoted to the Criminal Investigation Division in somewhere around November of 2017.
And are you a certified peace officer in the state of Texas?
Yes, I am.
Have you been a certified peace officer since graduating the academy?
Yes, I have.
So, and math's not my strong suit. Help me out with how long have you been a peace officer?
Since 2009, without having to math myself.
And tell me a little bit about the academy. What is the academy for?
Yes, sir. The Police Academy is a basic introduction to law enforcement. It's a school that all Texas peace officers have to complete prior to being certified. It ranges from learning about all the different types of laws, different types of tactics and techniques that law enforcement use throughout their day-to-day, and also gives just kind of a baseline understanding of the goals of law enforcement.
And as an investigator, do you have any additional training that you do or continuing training that you do?
Yes. As a peace officer, we're required to maintain minimum 40 hours of training, continuing ed training every 2-year cycle. I currently have over 5,500 hours of continuing ed training. And some of that stems from having an associate's degree from Jacksonville College and a bachelor's degree from Dallas Baptist University, and also a master's degree from the University of Texas at Tyler.
And Investigator McDonald, I want to take you back to November 25th of 2020. Do you recall that date?
I do.
Were you on duty on that day?
Yes, I was.
What was the function of your job that day?
I was a criminal investigator.
And were you conducting any kind of an investigation?
Yes, I was.
Without going into too much extraneous detail, can you tell me what the basics of that investigation was?
Yes, we were investigating a burglary that took place in Smith County.
And was the subject of that investigation an individual by the name of Russell Melton?
Yes, it was.
At some point, did your investigation lead here to Van Zandt County?
Yes, it did.
Where in Van Zandt County did your investigation lead to?
Is it okay if I reference my report for the address.
Would referencing your report refresh your recollection?
Yes, it would.
Go ahead.
We went to multiple addresses on or around VZ County Road 4909 and 4910.
And at some point, where was the end point of the Van Zandt County part of that investigation?
For me, it was that on 4910.
And who lived at that address?
I know that Reginald Young lived there, and there was a female that I believe lived there as well. I cannot recall her name.
And at that address, was that the address that you went to, was that in Van Zandt County in 2020?
Yes.
And you mentioned a Reginald Young lived there. Do you see him in the courtroom today?
I do.
Can you please describe what he is wearing and where he is seated?
He's seated at the table there, and he's wearing a light blue shirt.
Your Honor, may the record reflect this witness has identified the defendant as Reginald Young?
The record will reflect that this witness has identified the defendant in this case, Reginald Hoyt Young II.
And when you got to that property, what was it that captured your attention there?
There was a vehicle there that we were searching for that belonged to a Michael Ward, I believe his name was, and we came upon it. So that's what brought us to that location.
And at some point, did you find Michael Ward?
Yes, we did.
And did you also see Mr. Young there?
Yes, we did.
Can you tell me a little bit about how the case developed upon arrival?
We were able to locate some of the evidence directly related to our burglary in Smith County on that property.
As a result of finding some of that evidence, what was the next step that you took?
The next step was to generate a search warrant for the property to search for more evidence in our burglary that occurred in Smith County.
And can you kind of describe that property for me, like buildings, vehicles, things like that?
Yes, there was on that property, there was a mobile home. There was an RV parked and set up very close to the motorhome or the mobile home. There was a Mustang that we already discussed, and there was also an orange, I'd say a mid-sized SUV, Dodge Nitro.
And were you able to determine, you said a mobile home and an RV, were you able to determine who lived in what area?
Yes, we did.
And were you able to determine where Mr. Young lived?
Yes, we did.
Where did he live?
Mr. Young lived in the RV that was next to the mobile home.
And throughout this process, did you ever notify Van Zandt County law enforcement?
Yes, as a common courtesy, we did.
And what was their response to being notified?
They arrived on scene shortly thereafter.
And you mentioned earlier that you got a search warrant put together. Were you able to execute that search warrant?
Yes, we were.
What was found as a result of the search warrant?
We located a firearm that was found to be a violation of Texas law.
And Investigator McDonald, do you recall what happened with the firearm that you found?
I do not.
At that point, were you, as a Smith County deputy, interested in firearms or anything like that?
No, I was not.
Do you know if Van Zandt County law enforcement who was there was interested?
I believe they were.
Your Honor, state passes the witness.
Mr. Stevens, your witness.
Thank you, Your Honor. Investigator McDonald, I'm Bill Stevens, going to ask some questions. If I don't make myself clear, just please stop me, okay?
Yes, sir. Thank you.
All right. Now, how did you derive at the fact that Mr. Young lived at that travel trailer?
By his own words.
By his own words. Did he tell you that?
I was present during the interview that he was giving.
Okay. Did y'all, when you searched the property, did you find his clothing, shoes, clothing, underwear, things of that like that in the travel trailer?
I don't remember exactly what all was found. I remember we found other evidence. It's been 4 years since that day, so I'm not quite sure exactly.
Other than his statement, was there any evidence that you found that tied him to that travel trailer?
Yes.
What was that?
His vehicle parked.
His vehicle?
His vehicle was parked in the vicinity.
Okay. So because his vehicle's parked there, that means he lives there?
And his own testimony.
Now, your investigation, he was not the target of your investigation, correct?
That's correct. Okay. He was not.
And to your knowledge, was he arrested for anything other than the sawed-off shotgun?
Not that I'm aware of.
Okay. What was the investigation all about that led you out to that location?
It was a burglary of a habitation that occurred in Smith County.
And what kind of property were y'all actually looking for?
We were looking for gold, coins, and other precious metals, firearms, and items that were specifically taken from that specific residence in Smith County.
And again, Mr. Young was not charged with any of that stuff, correct?
That's correct.
Okay.
He wasn't charged with the robbery because it was somebody else who lived on the property that was found in possession of all those things, not him. So someone else who lived there had those. Convicted felon, though, in possession of a sawed-off shotgun.
Witness, Your Honor. Charwell, your witness.
Thank you, Your Honor. Investigator McDonald, we kind of danced around it earlier, but with the property that was stolen from the burglary, what was it that you located at this property?
Located a firearm. Oh,
from the burglary.
From our burglary in Smith County? I'm sorry. We located several gold coins.
And do you know approximately how many?
10.
I believe around 10.
And where did you locate those?
We located those inside the orange Dodge Nitro.
And that's the Dodge Nitro that you said belonged to Mr. Young?
That's correct.
And you mentioned earlier that you overheard him state that he lived on the property. Can you clarify the circumstances around that statement?
Yes, he was willing to speak to detectives and other officers there. And while he was talking, he advised that the RV travel trailer was where he resided.
And Your Honor, state passes the witness.
Mr. Stevens.
A little ping pong back and forth with this witness.
Investigator, who was it, the Dodge Nitro titled in? Whose name was it titled in?
I'm not sure who it was titled to.
Well, did you run a report on it?
I'm sure somebody did. That was not my part of the investigation.
Ask witness, Your Honor. Sherlock.
Nothing further, Your Honor.
Any objection to Investigator McDonald being finally excused?
Your Honor, we would ask subject to recall, but no objection to him going back to Smith County and just being within phone call.
Mr. Stevens?
No objection, Judge.
All right, so Investigator McDonald, you're not released at this time from the rule that I placed you under, so you'll still need to abide by that. You're not required to stay in the courthouse just so long as you're available by cell phone to the state and to the defense. All right?
Yes, Your Honor.
Let's just let me know.
Max sentence on this one, I believe, is 20 years. 20 years in the slammer. I think it's a range 2 to 20, I think is where it's at. So it can...
Does the state wish to call another witness?
Yes, Your Honor. The people will call Lieutenant Bob Kelner.
Lieutenant Keltner. All right, sir, if you'll raise your right hand, you swear that the testimony you give to the court today be the truth, the whole truth, and nothing but the truth, so help you God. What's your step? Through your testimony, it's important that you speak up loudly and clearly so that everyone can hear what you got to say. Allow the attorneys to finish their question before you start speaking, so we're not talking at the same time, which makes it difficult for my court reporter and for everyone to hear. If an emergency vehicle or a loud truck passes by, it causes maybe difficult to hear. Just stop testifying. The attorneys may even stop asking your questions. Okay. Mr. Hernandez.
Thank you, Your Honor. Good afternoon, Lieutenant. Would you please introduce yourself to the jury by stating your full name and spelling your last name for the court reporter?
Okay. Good afternoon. I'm Robert Aaron Keltner, Keltner. I often go as Bob.
And Lieutenant, I mentioned Lieutenant Bob Keltner. Is that your current title?
It is.
And which agency do you work for?
Van Zandt County Sheriff's Office.
And how long have you been with the Van Zandt County Sheriff's Department?
Almost a year and a half this time.
This time? So you have some prior law enforcement experience?
Yeah, I had a break in between 2021 and 2023.
And are you a post-certified peace officer?
I am.
Okay. And when did that certification first start?
I got my basic in 1991.
Okay. So how many years total in law enforcement have you had?
A little over 30. I had a break in the late 90s.
And what other agencies have you worked for?
I worked for the constable's office here, Precinct 4 in Van Zandt County. Been there almost 15 years, dual commissioned. And then, of course, the sheriff's office from 2017 to 2020. McCullough County Sheriff's Office in Brady, Texas. Did a short stint with the Van Police Department here in Van Zandt County, and the Kemp Police Department in Kaufman County.
And so fair to say that you've kind of come up the ranks and you started off as a patrol officer initially?
That's correct.
Okay. And when did you receive your commission for lieutenant here in Van Zandt County?
June of 2023.
Okay. So asking you to look back on to November 25th, the year 2020, were you working for the Van Zandt County Sheriff's Department?
I was.
Okay. And in what capacity? What title?
I was a sergeant investigator with in the Criminal Investigation Division.
And what were your duties in that capacity on that date?
I strictly worked property crimes or major crimes when it was necessary.
Do you have occasion to respond to 1255 Van Zandt County Road 4910 in Ben Wheeler, Texas, back on November 25th, 2020?
Yes, I did.
And was that location there and now, sir, in Van Zandt County, state of Texas?
Yes, it's in rural Van Zandt County.
Okay. Talking about middle of the day, maybe about 11:30, maybe noon. Does that sound about right?
Yeah, it sounds about right. We were there a good part of that day.
And how is it that you were called to that location?
The Smith County Sheriff's Office was investigating a property crime that occurred in their area, and they had ended up, as a result of their investigation, on 4910, and they requested us to come assist them, which is often the case when you're in somebody else's jurisdiction. You talk to who works there, at the very least, to let them know.
Because they were from Smith County coming into Van Zant.
Yes.
I believe there was testimony about a courtesy call. Is that what he was referring to?
Yes, that would be the case.
Okay. And upon arrival there at that location, who did you meet with?
Met with Deputy Kevin Londoff and Deputy Tim McDonald with the Smith County Sheriff's Office.
Okay. And did they advise you of the purpose of their call and why they were at that location?
They did.
Okay. And as a result of that, what happened?
So they were there, like I said, investigating a property crime, which was a burglary. They had had a significant number of gold coins stolen out of a safe in the northwest portion of their county. And they had followed up some leads that led them to that location. And they had two individuals that they had detained there and were trying to forward their investigation.
And at any point, were you able to observe whether they were actually conversing with those two individuals?
I believe so. They were talking.
Okay.
To those folks.
And one of those individuals, do you see that one of them here in the courtroom today?
I do.
Do you see Reginald Young, the second, here today?
Yes, sir.
Would you please describe where he is seated and what he is wearing?
He's seated here next to his attorney in a button-down shirt with his glasses on.
Your Honor, I'd ask the record to reflect identification of the defendant by this witness.
The description is a button-down shirt with glasses on, sitting next to an attorney. I'm not sure that that's a sufficient identification because they're both wearing button-downs. They're both wearing glasses. Okay. There's no presumption that one's an attorney over the other.
Okay.
Do you see somebody wearing a suit?
Yes, I do.
And who is that? Do you know?
I would assume that is his defense attorney.
Okay. And the person sitting to his right?
It is Reginald Young, a person I know is Reginald Young.
Okay. You know him as Reginald Young?
Yes.
At this time, I'd ask the record to reflect identification, Your Honor.
All right. Record will reflect that this witness has identified the defendant, in this case, Reginald Boyd Young II.
Now, Lieutenant Kelner, I'd like to ask you about body-worn cameras going back to November 25th of 2020. Were those in use at the time by the Van Zant County Sheriff's Office?
I believe that I had one issued to me there in that time, yes.
Okay. And do you recall if that body-worn camera was used by you on that date when you responded to that call?
I don't recall. We were leaded up to the transition from one administration to the other. I don't remember whether I'd turned it in or whether I was wearing it that day.
And do you recall anything about CID and whether or not there was a policy as to whether body-worn cameras would be worn by those investigators?
I don't recall a policy requiring CID to wear them at that time.
Okay. And so to your knowledge, did the deputies interview the defendant, Reginald Young, at that location?
I know that they did talk to him, yes.
Okay. And as a result of that investigation, do you know if any of the alleged stolen property was found on scene?
As I recall, he did not consent to a search, so they were required to get a search warrant to advance their investigation there.
And was a search warrant obtained to lawfully conduct a search on that property?
It's my understanding that the Smith County Sheriff's Office, those deputies that were out there, had obtained a search warrant for that location, yes.
And did you participate in any way with the processing of that area after the search warrant was signed?
Oh, yes. I assisted with searching a vehicle and other locations, yes.
Well, they're taking a second to pause here. I found a spicy city council meeting out of Texas. It's 5.5 hours long. And I believe 2 people quit during it for various reasons. It's nuts. We might look at this. Wow. Why are we sitting here quietly? I was not paying attention. Always consulting with his client. Pulling all-nighter for city council. There's allegations of bribery. At one point, somebody's saying,
I may approach the witness, Your Honor. You may.
I've got your wife in my DMs.
Sir Kelner, I'm handing you what's been marked for identification purposes as States Exhibits 1, 2, 3, 4, and 5. Without actually displaying them to the jury, I'd ask you to take a look and see if you recognize those.
Yes, I do.
And what do those purport to be, sir?
All right. Number one is looks like an upright freezer.
Now, well, let me ask you a more general question. Are those all photographs? Do they appear to be photographs?
Yes, all 5 of them are photographs of what I recall to be the location of the search warrant.
Okay. And do they each and every one of those, 1 through 5, clearly show the situation and what you observed back on November 25th, 2020?
Yes.
They've not been changed or altered in any way?
Not to my knowledge or detection, no. They look just like what they did back then.
At this time, I'd move for the admission of States Exhibits 1 through 5, Your Honor.
No objection, Your Honor. Are there being no objection, States Exhibits 1 through 5 are admitted?
I may approach the witness, Your Honor. We'd like to ask permission to publish at this time.
Yes, sir. Granted.
I'm not sure if we get to see these or not. I think he hands them off to the jury. Let's see. Oh, he's putting them on a screen, but I'm not seeing it. He's got an Elmo.
And Mr. Alternate, sir, Mr. Alternate, if you want to, you're welcome to bring your chair out. You can slide your chair out here so that you can get a better view so that you're not having to crane your neck up. Deputy Martinez, if you'll help me.
Pull up your chair next to the defendant. Strike up a chat. Everyone's moving their musical chairs today to get a better view, except for us.
Am I on?
Yes.
Lieutenant Kelner, so would stand identified now and marked as States Exhibit 1. Started to comment on that. What is that item?
It appears to be a stand-up freezer that was against the travel trailer at that location on 4910.
Okay. And do you recall what the makeup was? There's been a travel trailer discussed and a mobile home as well. Are those 2 separate?
Yeah, two
quarters?
Yes, 2 separate residents, I guess, or living quarters. Yes,
okay.
2 separate.
And this refrigerator or freezer, I believe is how you refer to it, is in front of, is that the RV?
Yes, the RV travel trailer, yes.
I'm going to show you States Exhibit 2.
Mm-hmm.
Is that same freezer?
That's open? Yes, it's the interior of it, yes.
Okay. And do you recall seeing, what is the item there on that center shelf?
That's the breakover shotgun in question today.
States Exhibit 3 here. It's more close up. You see that there?
Mm-hmm.
Is that the same shotgun you're referring to?
Yes, it is.
And to your recollection, was there another firearm that was also located?
There was.
States Exhibit 4. What is that there?
It's a .22 long rifle with a scope on it.
That's this here.
Mm-hmm.
And is that where it was located once law enforcement went into that RV?
Yes. Now,
Close up here, States Exhibit 5. Right.
yes.
Now, who actually took possession of these two firearms, Lieutenant Kelner?
I believe I did. And I transported them back to the sheriff's office in Van Zandt County.
Back on States Exhibit 3. Let me approach the witness, Your Honor.
You may.
Lieutenant Keltner, I ask you just to take a quick look and make sure that this item is safe. Ask you to identify it, please.
Okay, it is safe. This is a breakover shotgun that has been had the stock removed and the length of the barrel, or a length of the barrel.
Okay. And there's been some mentioning of a sawed-off shotgun. Is that the item in question?
That's how I would describe it. Yes, it does appear that the barrel was sawed off with most likely a hacksaw or something to that effect. That's what it appears. It doesn't. It's not clean. It does not appear to have been professionally modified.
Okay. Are you aware of instances where an item like that, a shotgun, can be professionally modified?
Yes, I would think so. I would think a gunsmith would be able to professionally modify a gun like that.
Now, are you aware of what the definition of a prohibited weapon is, Lieutenant?
Not verbatim, but yes.
Okay. Well, in measurements, what are we talking, and what would you be looking at?
The barrel should be at least 18 inches long, and the overall length should be 27 inches long, minimum. Otherwise, it requires a special permit or tax stamp.
And that's actually the item that was recovered from Reginald Young back on November 25th, 2020.
That is correct.
Does it appear to have been changed or modified in any way other than the identifying information that's attached to it?
No.
Your Honor, at this time I move for the admission of State's Exhibit 6.
Objection to State 6.
Oh, it's the sticker. No objection, Judge. No.
All right, there being no objection, State's Exhibit 6 is admitted.
That is a short handle, short barrel shotgun for sure.
Deputy Martinez, will you get this from Lieutenant Kelton?
It's a breech load, so you have to like break it open like that. Break barrel. It breaks down, then you take the one shell out, you load a new shell in, close it, then you can fire it, then you break it down, take the old shell out, put the new one in, close it. It's not a rapid fire.
Your Honor? Yes, sir, you mean.
It's a pistol with the benefit of a shotgun.
Keltner, I'll ask you to take a look at what's been marked for identification purposes as State's Exhibit 7. It's a box currently there. Can you take a look to see if it bears any identifying information?
I'm guessing this is a Ruger 1022.
And whose name appears on that box?
My name appears on it.
Okay. And do you know when that box would have been put together in that fashion?
Well, I collected it on November the 25th, 2020. I did not box this particular piece of evidence myself.
Okay. But you actually brought an item from Mr. Young's residence back to the Sheriff's Department.
That is correct.
At this time, I'd ask you to go ahead and break the seal on the box and then look at the contents without actually pulling out that item.
The seal is already broke on it.
Okay.
What? The seal's already broken?
Does that look to be fairly the same item that you recovered back on November 25th, 2020?
Yes.
Has it been modified, changed in any way?
It appears that the scope has been removed from the top of the rifle.
Okay.
This is my handwriting on the tag.
If you wouldn't mind just taking a quick look and making sure that it is safe.
Looks like it's permanently attached to the box, so it would be quite difficult to fire.
Can I cut it out of the box?
Yes, you need Deputy Martinez's knife.
No, I have one if that's all right.
Yes,
I bring my own weapons to court. Got the switchblade here. Ooh, cuts towards himself. Bold move. Man. Puts the old timer away. Oh, there it is. Synthetic stock.
I believe the weapon is safe.
All right.
Can't tell if it's a Ruger
It is
or
on
not.
safety.
Ruger,
Your Honor, at this
Remington.
time,
Not sure.
the state would move for the admission of State's Exhibit 7.
Any objection to State 7?
Your Honor, I got a couple of questions of the witness. States Exhibit 7.
All right, go ahead.
Officer, you testified just now that the seal had been broken on the box.
Yes.
Okay. Did you break the seal?
I did not.
Do you know who broke the seal?
I do not.
I'll object to the admission of this evidence, Your Honor. Seal's been broken. He
Chain of
doesn't know
custody.
who broke the seal. We don't know that was actually the weapon put in there at the time.
Response from State.
I believe he testified that it is the weapon, Your Honor, that was placed in the box, other than the fact that the scope was taken off the weapon. That was the testimony.
All right, then the court will overrule the objection and State 7 is admitted.
Please note my objection.
Yes, sir. It is noted for the record.
If I may approach the witness, Your Honor. Seal it up.
They're going to rebox everything and pretend nothing happened. Who broke the seal and stole the scope?
You just laid on the floor.
All right, sir. Thank you. Now, Lieutenant Kelner, I'll make reference back to State's Exhibit 6, but it has been admitted there. And handing you a standard Stanley 12-foot measuring tape.
Okay.
You testified to the fact that there's a certain length that you're looking for and what qualifies as a prohibited weapon. What was that number in terms
Anything
of
under
barrel length?
Anything under 18 inches.
Would you please take a moment and measure the length of that barrel there?
Shows a 16th over 11 inches.
So that's almost
11
7
inches. Yeah, 11 inches and a 16th.
And it should be
18 inches. So it's well under.
7 inches.
Yeah.
I think even I can do that math. All right. And then you also stated that there was a overall length that you're looking at.
Of 26 inches.
And would you please just take a moment and measure that?
Give me just a moment. I need to.
Need to render the gun operable so I can measure it in the closed position. We now have a nearly functional firearm. The mug is more expensive than the measuring tape by far.
The overall would be approximately 19 and a half inches.
And where does that compare to what the law would require?
It'd be 7 inches under.
As well.
As well.
If I may approach, Ron. Thank you. Attach that back.
Yeah.
Now that he's broken it, or he's broken the zip ties.
All right, Lieutenant
Kelner, the jury box?
let me ask you, do you recall meeting with the defendant, Reginald Young, on December 4th, the year 2020?
I do.
And where did that meeting take place?
At the Van Zandt County Sheriff's Office.
And you had a conversation with him?
I did.
Who else was present in the room other than yourself and the defendant?
Special Agent Josh Petri with ATF.
Mr. Hernandez, I'm going to allow the alternate.
Yes, please.
Seat back there. Oh, yeah. I don't want him to feel like he's on trial.
Well,
yeah.
Thank you, sir. And so you said it was yourself, Josh Petri with ATF, and Mr. Young.
That's correct.
Okay. And do you recall if he was advised of his Miranda rights on that date?
He was.
Okay. And was that in a matter of just spoken word, or did he have an opportunity to review a formal advisement form?
Agent Petri advised him orally and then referred to a written document advising him of his rights.
And the defendant signed the statement?
He did.
Indicating he knew what his rights were and he was waiving them?
That's correct.
If I may approach.
You may.
And what's been marked for identification as State Exhibit 8. Recognize that document?
I do.
And does it bear any identifying information on it?
It has Reginald Young's name and his signature, and it has my name and signature and the date and time.
And is that the form that you were just talking about where he was advised of his rights and then waived those rights and signed the document?
Yes, sir, that's correct.
That form appeared to have been changed in any way or doctored?
It does not.
Your Honor, this time I move for the admission of State's Exhibit 8.
No objection. There being no objection, State's 8 is admitted.
The rights were conveyed by
so
interpretive
after advising him of his Miranda rights, Lieutenant Keltner, what did the defendant share with you
by an Australian
in reference to
breakdancer.
that sawed-off shotgun? What did he tell you?
We had a discussion, and Mr. Young stated that he had moved the sawed-off shotgun from his vehicle to the freezer that's in the photograph.
And at any point, did you have any conversation regarding where he lived or who actually lived in that
freezer is not a gun
RV?
safe.
Or
I mean, that's where he was living. Yes. I mean, I don't recall whether it was during that interview or not, but the RV where that upright freezer was and where the .22 long rifle was recovered was where he was living.
And there was another person contacted there. There was a female. Do you know who that was?
That was Mr. Young's girlfriend at the time.
Okay. And so both were there on property when you arrived?
Yes.
Now, specifically as to the sawed-off shotgun, you made reference that he took it out of the vehicle. Do you recall a conversation regarding the rifle that's been admitted as State's 7?
Yes, we talked about the rifle.
And what did he say about the rifle?
I believe that he had said that he had shot the rifle to eliminate varmints or rodents around his residence there.
Did you mean that or take that to mean that he knew he had both weapons on his property?
Absolutely.
Was there any hesitation on his part when he talked about how that sawed-off shotgun got into the freezer?
No, I believe he was honest.
And he said that he moved it from the car to the freezer.
That's correct.
I have nothing further, Your Honor. I'd pass the witness. Thank you.
Mr. Stevens, your witness.
Thank you, Your Honor.
I'll start working on that right now.
Lieutenant Kelner, I'm Bill Stevens. I'm going to ask some questions. If I don't make myself clear, just please stop and let me know.
Okay.
So when you went out to the property, did you personally search the travel trailer?
I don't recall searching the interior of the travel trailer myself.
Okay. Do you know who might have searched the interior?
There were a number of deputies from Smith County there, but I don't know exactly which one it was.
Okay. And so what exactly was your purpose in being there? I know you were called in because it's one department's there and they need to call in you, but so tell me exactly what was your purpose in being there?
Primarily to assist them being in Van Zandt County. I was previously aware of the burglary that they were working on. It had occurred close to Van Zandt County, and we had some dealings with the suspects that and had some cases with the suspect on the case that they were working on.
Okay. Now, my client was not charged with anything related from the burglary. Is that correct?
That's my understanding.
Okay. And this .22 rifle that was found, it's not an illegal rifle, is it?
No, it's not.
Okay. So he wasn't charged with that. Possession of that.
Your Honor, can we approach real quick?
You can.
All right, while they approach, I'm just finalizing my rap song, Miranda Rights. I'm going to call it Know Your Rights. Let's see how it does here. Just give me a second. I object to the knot on that tie, the striped one. That's not good.
You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read to you? With these rights in mind, do you wish to speak to me?
Your Honor, I'll withdraw that last question. Lieutenant, did you take any fingerprints from the shotgun?
I did not.
You did not. Do you know if anybody took any fingerprints?
Not to my knowledge.
Okay. Did you ever see Mr. Young possess? I mean, with your eyes, did you ever see Mr. Young possess the shotgun?
No, I did not see it in his hands or on his person. So no, I did not.
Okay. And tell us again where this refrigerator was located that had the shotgun in it.
Okay, so in the photograph that you can see there, there's what I would describe as a double wide trailer house. I believe it's a double wide where Mr. Young's mother lived at that address, and then off to the east side there was his RV that set not perpendicular but at an angle to the double wide where Mr. Young was living. And I'm sorry, to more completely answer your question, there was a refrigerator in that stand-up freezer that was against the RV on what I would describe as the west side.
Okay. Was it on the RV, like on a porch, or was it on the ground?
I recall it being on the ground, not a porch. I don't recall an improved porch.
Well, so it wasn't inside the travel trailer itself, the refrigerator?
No, it was not on the inside. The freezer and the refrigerator were not.
Were there several travel trailers and whatnot in that general area that people lived in?
On that road, yes.
Yes, sir.
Yes, on that road, yes.
Okay. And how about on that particular property where you were?
I don't recall any other structures besides the travel trailer RV and the double wide. I do recall there being a shed on the west side of the property, but I don't recall anybody living in there. I believe it was for storage.
Do you recall a building or a house being tore down at the time you were doing your investigation?
I think that the storage building may be what you're referring to, but I don't remember it being tore down.
in the process of being demolished.
I suppose that's possible, but the structure appeared to be erect at the time. I don't recall it being.
Okay.
I mean, it's not like it was in pieces or anything. I remember it having 4 walls and a roof and having a number of items would appear to be in storage inside of it.
Okay.
Of course, there's a shed.
So is that sawed-off shotgun operable?
So I would not consider it operable at this time. No.
Looks to me more like a, I don't know, some kind of relic or something that you'd see hanging on the wall. Perhaps. Any idea? Do you have any way of determining the last time that shotgun was fired?
I do not. No, sir.
Okay. Did you go inside the property? I think you answered that. I want to ask you one more time. Did you go inside the property?
Okay.
The travel trailer.
I believe that I looked inside the travel trailer after they were done searching and discovered the rifle, but I didn't spend much time in there if I did.
Okay. I noticed on State's Exhibit number 6, I believe it is. I'm sorry, on State's Exhibit number 4, it shows the pick of the shotgun, and it shows a pill bottle on a table next to it. Did you happen to look at the pill bottle to see whose name was on it?
I don't recall doing that, no.
Okay.
The defendant is quite active in his defense on this one. I've so far struck out on 6 AI songs. They've been terrible. Not worth playing.
Pass the witness, Sharp.
Your name is your witness.
Thank you, Your Honor. Lieutenant Keltner, in your 30 years of law enforcement experience, have you ever followed up and asked that an item be dusted for fingerprints if the suspect had admitted to possessing or moving the item?
Oh, no, sir, no.
And in this instance, did you feel it necessary to dust the sawed-off shotgun for fingerprints?
No, sir.
Why not?
Because possession was identified. It was not necessary to find an unknown person, as to who possessed it.
Did he in any way admit to ever having touched it?
He did admit to touching it.
What did he say?
He said he moved it from his vehicle to the location where it was discovered.
In the freezer?
In the freezer. I don't recall that he said it was a freezer, but he moved it out of his vehicle to that location.
Now, counsel asked you about a relic. In your 30 years of law enforcement, maybe even longer, have you ever come across an item that, in your mind, was a relic?
I would say yes.
How would that item appear to you?
As an example, I guess weapons and anything else that would be of age could be in a various degree of condition. Mm-hmm. Some things are in better condition than others. As an example, I've been to a gun store where they had a weapon that was documented to have been produced during or shortly after the Civil War. It was sold to the United States Army, and it had returned to the manufacturing plant to be modified, and then had returned to service. And somehow it ended up as in private ownership. And I would say that that's a relic or an antique, but it was still in serviceable condition, and it had paperwork to go along with it.
Is it fair to say that the term relic would make you think of something being hung on a wall?
I would think of it that way, yes.
It may have a plaque identifying dates of service.
Very possibly.
It would have paperwork for its authenticity.
Yes.
Counsel also asked you about whether that sawed-off shotgun is operable. What would it take for it to be operable?
Simply sliding a firing pin into position and loading it.
How long would that take to slide that firing pin?
Just a few seconds.
No further questions, Your Honor. I pass the witness.
Stevens, you witness. Thank you, Your Honor. Lieutenant, could anybody without experience put a firing pin in there? Would they know how to do it?
Well, I don't know. That would cause me to speculate as to whether they would know how to do it. I would think that anybody who was capable of placing a round peg in a round hole would be able to figure it out.
So where would you get a firing pin?
I would think that any gun store, or that the firing pin may have become dislodged and may have been available with the weapon.
Did you locate a firing pin?
I did not.
Did you look for a firing pin?
I did not.
Okay, I think we've got a winner on the Miranda rights
Yes,
song.
witness, Your Honor.
No, nothing further, Your Honor.
You ready for a break? Ready for a brief break, or we'll listen to Miranda rights?
Your Honor, we ask that he remain subject to the rule.
Okay. Cool. So follow that. Without it's subject to recall like the state or things.
Okay, so I can go vote?
Yes, you can go.
Okay, all right. Thank you very much.
Yeah, you're free to go about your job. Just know that they call you, they can store in the rule not to discuss the case or discuss it with anyone else if it's testimony or negligence.
Very good. I'll keep myself on.
What's your step?
If I may approach the bench, Your Honor.
Okay, we're going to pause for just a second. Audio only, new song about Miranda rights. It doesn't have all the rights. I tried to make one like with the script, Miranda rights script in it. It doesn't work very well. It just like reads it off to music, and it's not very good. This one hits a little harder. As is tradition, we started with true rap style. A rap song about Miranda rights was the prompt. Here we go. Oh yeah.
Yo, I'm spitting truth from the box edge. Work sharper than the cop's edge. No pledge. Miranda reading out, no misconstrued. Sounded like a vault, lights kicking, no feud. Yo, when they cuff ya, stuff ya, rough ya, all flying high, justice buffer. Read them aloud, it's the right call. Caught in the net but never fall, stand tall. Yeah, when they cuff ya, stuff ya, rough ya, all flying high, justice buffer. Read them aloud, it's the right call. Caught in the net but never fall, stand tall. Yeah, you have the right, that's the phrase. No speaking till a lawyer plays. Anything said, courtroom plays. No confessions, trust silence stays. Grimy precinct lights, reflections of fate. Lines blurred but them rights straight. Tongues tied what the lawyers embrace. Miranda be that ace, true space. Gavel hits, echo in the hall. Miranda there to catch the fall. Speech got limits, walls and all. Freedom in the silence, you stand tall. Detectives read stories, tight as braid. No words slipping through leather parade. Guarded speech rights we parade. Justice on the edge, sharp as blade.
I think it did okay on this one. It continues to remix a bit more here.
Yo, when they cuff ya, stuff ya, rough ya, all flying high, justice buffer. Read them aloud, it's the right call. Caught in the net but never fall, stand tall. Yo, when they cuff ya, stuff ya, rough ya, all flying high, justice buffer. Read them aloud, it's the right call. Caught in the net but never fall, stand tall. When they cuff ya, stuff ya, rough ya, all flying high,
it's pretty catchy. When they cuff ya, stuff ya, buff ya.
It's the right call. Caught in the net but never fall, stand tall. Yeah, bringing precinct lights, reflections of fate. Lines blurred but the right straight. Tongues tied with the lawyer's embrace. Miranda be the ace, true space. Gavel hits, echo in the hall. Miranda there to catch the fall. Speech got limits, walls and all. Freedom in the silence, you stand tall.
All right. That's as far as we're going to take that one. It just continues for a few more minutes. But some pretty catchy tunes there. I think AI has had a run-in with law enforcement that didn't go well. I think whoever programmed AI has had a bad experience with the law. All right, back in court. Here we go.
Yeah, man, you always been all right. You know the.
Is he just shaking hands with the defense?
Additional witnesses.
Yes, Your Honor. State calls Agent Josh Petri.
Josh Petri.
The lines blur, but the rights are straight. No speak until the lawyers blaze. Where does that come from?
Third, you swear that the testimony you give before today, truth, the whole truth, and nothing but the truth. So, yes. See, Martinez, during your testimony, support that you speak up loudly and clearly. You have to lean the microphone. During your testimony, if the attorneys object, Justin Donovan, the court will rule on that. Allow the attorneys to completely finish their question before you give an answer, so we're not talking at the same time. For purposes of a clear record. Finally, if you're in the emergency vehicle or mouth shut, something that makes it difficult because the line of that sound pass, the attorneys are making stop or questioning during that time.
Okay.
Sure.
Thank you, Your Honor. Good afternoon, Agent Petri. Can you please introduce yourself to the jury by stating your full name and spelling your last name for the court reporter?
My name is Joshua Petri, Petree.
And can you tell me what you do for a living?
I'm a special agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
What does somebody have to do to become a special agent with the Bureau of ATF?
Well, we investigate federal crimes. So typically, like I have a bachelor's degree. I was a police officer prior to. And so there's different paths, but typically you're prior law enforcement before you become a federal agent.
So starting kind of with your education, what do you have a bachelor's degree in?
So I have a associate's degree in criminal justice, a bachelor's degree in criminal justice, and a master's degree in business administration.
And about how long did it take you to get those degrees?
Long time, approximately 10 years. I was a police officer while I was also going to graduate school.
And where were you a police officer at?
University of Texas at Tyler.
And to be a police officer with UT Tyler, did you have to be a certified police officer?
Yes, I went through the UT police system in Austin, Texas.
Can you tell me a little bit about that system?
It's a 6-month training, typical police academy where you're learning policies and procedures, state penal codes, arrest techniques, driving techniques, shooting, hand-to-hand techniques, various generalized law enforcement.
And about how long were you a police officer?
4 years.
And is it at that point after your degrees and your experience as a police officer that you applied to be with the ATF?
It took me 4 years to be hired. So while I did an internship with ATF when I was going to UT Tyler on my undergraduate degree, knew that was my goal, became a police officer to gather the experience. The hiring process was approximately 4 years.
Can you describe a little bit about that process?
Process of being hired?
Yes, sir.
It's very stringent. Typically, ATF has 2,500 federal agents throughout the United States. It's always been about that size. Our attrition is usually people that retire. It's approximately 100 agents a year. They open up the vacancy announcement, which is the generalized open application process. Typically, 5,000 to 10,000 people apply. They hire about 100 a year. So it's very, very stringent.
And once they hire you, can you tell me a little bit about that process?
Yes. So they sent me to Tulsa, Oklahoma. I got the duty agent phone call that said I was being hired and went to Tulsa, Oklahoma, worked there for approximately 6 months till I was assigned an academy date. ATF attends a training academy in Glencoe, Georgia. It's also where, at the time, Border Patrol, U.S. Marshals, Customs, Secret Service, a lot of your federal agencies have combined training at this one facility in Glencoe, Georgia.
And so would Glencoe be kind of the equivalent of like Quantico for FBI?
Yes.
And can you tell me a little bit about your experience at Glencoe?
Sure. The entire training process there was approximately 6 months. Half of that was a generalized investigator training for those that basically didn't have law enforcement prior to. It taught you the laws and procedures and techniques of investigation, typically, because we are criminal investigators. And then the second half was more specific towards what we deal with as ATF agents: alcohol, tobacco, firearms, explosives, commercial arson, stuff more specialized towards what ATF agents do in general.
And so you mentioned some of your college education. Do you have any furthering education specific to while you've been on the job?
Yes, I'm also considered a firearms interstate nexus expert. What that means is I'm an expert and have been declared expert in numerous courts throughout the country of identification of firearms, the markings, where they're made, when they're made. I've toured numerous manufacturing facilities throughout the United States. I also go back and teach various blocks of that at our training academy.
And Your Honor, may I approach the witness?
Okay.
And Agent Petri, I'm going to show you what's in large and admitted the State's Exhibit 6. Can you take a look at that item?
Yes.
Can you describe what that item is?
This is a weapon made from a shotgun. It can be classified in two different manners. Weapon made from, because lawfully to possess firearms like this, they have to be an overall length of 26 inches, and or the barrel has to be at least 18 inches long because it's a shotgun. And it's obvious that this one has been shortened on both the buttstock and the barrel.
And would you classify, so that appears to be a modified shotgun?
Yes, it originated its life as a shotgun that people would fire from the shoulder, typically for hunting of birds or things of that nature.
So in your training and experience, does that appear to be a prohibited weapon?
Yes.
And is that due to the length?
Yes, these are considered concealable. Therefore, they're prohibited because they can be hidden under trench coats. The laws were originated with these weapons back in the early 30s when mobsters would carry them in Tommy guns underneath their trench coats because they're considered weapons of violence and they're readily concealable.
And Agent Petri, can you tell me, does that shotgun appear to be readily operable right now?
It meets the definition of a firearm. I haven't actually tested it to see if it functions, but it was intended to be a weapon, and it is capable of being readily converted to fire if it won't fire in this form.
And if I told you that the shotgun did not have a firing pin, could you tell me the process that it would take to
if that's the case, it's a pretty simple procedure to drop a firing pin in. This type of shotgun right here was manufactured by a J. Stevens company in the early 1900s to the 50s. They sold these types when they were in original form in like Sears and Roebuck's catalogs back in the day. There's probably hundreds of thousands, if not millions, of these very similar type shotguns that could use interchangeable parts.
And
have you tried to insert a firing pin to see if one will fit?
Kind of turn your attention to your when you became involved in this investigation. Do you recall December 4th of 2020?
Yes.
And did you have a chance to interview Mr. Young on that date?
Yes.
And Your Honor, may I approach again?
Yes, sir, you may.
Thanks. I'm going to show you what's been admitted as State's Exhibit number 8. Do you recognize that document, sir?
I do.
What is it?
This is a U.S. Department of Justice Advice of Rights and Waiver, commonly a Miranda waiver, that is either read by somebody that you're interviewing. Typically, they're in custody, and I often read it to them and ask the person I'm interviewing that's in custody that has the right to an attorney if they want to waive that privilege to continue with the interview.
And is that the process you followed on December 4th of 2020?
Yes.
And did Mr. Young indicate that he understood his rights?
Yes.
And did he indicate that he wished to waive his rights and speak with you?
Yes.
And Your Honor, may I approach again? Thank you. And do you know whether Mr. Young was recorded?
Yes, it was.
Have you had an opportunity to review that recording?
Yes.
And the recording that's on that thumb drive, does it appear to be an accurate representation of the conversation?
I don't know what's on this thumb drive. This appears to be a way a typical interview recording would be turned into the prosecutor's office. It's labeled with the case number, things of that nature, but without seeing what's on the thumb drive, I honestly don't know.
And Your Honor, at this point, the state would request to give Agent Petri a chance to view the thumb drive to make sure that it is, in fact, the interview that he conducted.
What's the video?
The entire video is about 15 minutes, Your Honor.
All right, of course, going to stand in recess for 20 minutes to allow the witness to take the content on State's Exhibit 9. You are reminded that you've not heard all of the evidence in this case, not received the court's instructions on jury charge, and you've not received closing arguments, you've not discussed this case one another or anything else, okay? So you're not required to stay in the jury room, go outside, take a break, welcome to do so. It's 20 till 3, so let's make sure that we're back in the jury room no later than 3 p.m. and make sure. Okay. All rise.
The country music song did a much better job than the rap song. This is the witness's back shot. There goes the jury. We did see the jury. Yes, we get to see them in this trial. They've also announced their names. The official court record that's published by the court includes all their names. Court's in recess. We're going to go blip and teleport forward in time. I'm going to take just this moment before Judge Martin starts playing. We've got one more. And this one's going to be the country music version, because I know a lot of you are not rap fans. And I hear you. I hear you on that front. So let's see. Let's go down here to this one. Oh, yeah.
Was a Friday night in a dusty old town. Sirens wailed as the sun went down. They pulled me over on that lonesome road. Flashing lights made my heart explode. They said, son, step out and talk to me. But my daddy's words rang clear as can be. Keep your mouth shut, don't you be a fool. You got the right to silence, it's the golden rule. Know your rights and don't say a thing. Wait for your lawyer, let that phone ring. Keep your head down, don't make a sound. Miranda's words, best advice around. They pressed and pried, questions so sly, but I stared straight, didn't bat an eye. You got the right to remain silent, they sighed, tried to catch me slipping, but I denied. I need my lawyer before I speak. You're not trapping me in that game of hide and seek. They scribbled notes, but it didn't matter. My lips were sealed, their hopes just shattered. Know your rights and don't say a thing. Wait for your lawyer, let that phone ring. Keep your head down, don't make a sound. Miranda's words, best advice around.
There you go. Moving up the charts to number 10 this week on our country music top 40. Miranda's rights, best words around.
Know your rights and don't say a thing. Wait for your lawyer, let that phone ring. Keep your head down, don't make a sound. Miranda's words, best advice around.
All right. Big thanks to Suno, who created that song about 3 minutes ago, out of thin air. So, back to court.
So, no, somebody just needs, they'll just move on down. That's what I'm saying. There's no assigned seating. If
Just everyone sit down.
Sit down.
Just sit down.
Make it easier that way. All right. All right, you may be seated. All right, welcome back, ladies and gentlemen. We're back on the record, cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. Record reflects that the attorneys for the state, attorney for the defendant, and the jury is present. I believe that before the recess, there was a question to Agent Petri regarding State's Exhibit 9. Just to refresh the recollection of the jury. If we'll go ahead and pick up there. Go ahead, Mr. Harwell.
Thank you, Your Honor. And Agent Petri, have you had an opportunity to view the video that's on State's Exhibit 9?
Yes.
And does that video appear to have some muted portions?
Yes.
What is your understanding of those muted portions?
Parts of my conversation with Mr. Young involved things not relevant to this particular criminal investigation.
And other than those portions, is it a true and accurate copy?
Yes.
Your Honor, State offers State's Exhibit 9 with agreed redactions.
Any objection?
No objection, Your Honor. We've reviewed it.
Okay. Then State's Exhibit 9 is admitted.
And Your Honor, permission to publish to the jury?
Granted.
And Your Honor, the alternate would.
Yes, sir. If you want to move out, you can, or if you just want to turn your chair and slide it back, if that's fine. Just whatever is most convenient for you. Yes. And if you could probably roll that cabinet back too, Mr. Harwell, if you want to. There's still room.
There's a link to the country music version if you want it. Tell you, I'm just giving out gold album, platinum album
Stevens, can you see it
songs
from there?
right and left.
Yes, sir. Excellent. You see it okay?
Are we not going to be able to see any of this? Not even playing on the TV next to me. We're going to skip this if it just sounds like Charlie Brown's teacher the whole time. This is recorded on a potato played on a turnip in a courtroom with bad echo. You guys, we're gonna skip this. We're gonna skip forward until Until somebody talks. Because you can't make heads or tails of that. We're flying through court at this rate. Still going on. Still going on. Now we back up. Okay, he starts using his hands to talk. Almost done. There we go. He sits up. There we go. There's the end. Have no clue what happened.
And Agent Petri, I just have a couple of follow-up questions. Was there anything that stood out to you about Mr. Young's discussion about firing the .22 rifle?
Yeah, my knowledge of the investigation, the .22 rifle is in close proximity to the sawed-off shotgun.
And what would that, the proximity and firing the .22, what would that indicate to you?
The knowledge that the firearms are there, knew that one worked and one didn't, which meant must have tried, or he's told me that somebody else did, but.
And there was some discussion about a firing pin, and you had mentioned that it doesn't matter according to the law. Does not having a firing pin, does that make a weapon not a firearm?
No, it just says it has to be readily converted or is intended to be fired by the means of an explosion. A firearm itself is a weapon, whether it's fired or not. It can be pointed at somebody and have the same intention. But if it's created to be a firearm, then it's a firearm.
Readily converted.
And then
can you prove that
your discussion about the fingerprints on the shotgun seemed Mr. Young was kind of equivocating there. What does that tell you in your experience as an agent?
That's a typical question I ask because a lot of people watch CSI, think that we get fingerprints off of everything, which is not accurate at all, especially when they're dealing a weapon like this. But what it does is it gives a measure of truthfulness. And when I saw him start to stammer and sputter, which is a common deceptive technique, I knew that he was probably worried about that question.
And then when you mentioned not looking to charge Mr. Young's mom, can you go into that a little bit and that exchange?
Correct. Throughout that interview, Mr. Young was trying to what I considered minimize his criminal involvement with this. He knew I was questioning him about it. So ways of doing that are to minimize what I knew or what I had, and then also try to place the blame on others. I could tell throughout the interview that although he acknowledged he knew it was there and in its presence, he was trying to blame, he tried to say that his mother went and got it after he initially told me that Mr. Waddell called him. He said that Mr. Waddell, his mother went and retrieved them and then brought them back to the house, which I informed him that is a violation of federal law because that's a prohibited weapon. And I wasn't looking to get his mother in trouble. The charge, when I used the word charge, meant get your mother in trouble. I just wanted the truth. I could tell that he was trying to deflect.
And then last question, are you familiar with, to your knowledge and experience, is there a definition for an antique gun?
Yes.
And would this firearm meet that definition?
No. Antique firearms are like muzzle loading firearms, black powder. They use an antique ignition source, or if they're manufactured prior to 1898. I'm familiar with these firearms. They were manufactured well after the 1900s, and it doesn't use an antique ignition system and doesn't take black powder. So it's what we consider a modern firearm.
Okay. Your Honor, state passes the witness.
Mr. Stevens, your witness. Thank you, Your Honor. Special Agent Petri, I'm Bill Stevens. I'm going to ask some questions. If I don't make sense, please just stop me.
Yes, sir.
All right. Now, was Mr. Young pretty much cooperative throughout that entire interview?
Yes.
I'm going to pause just for a second. For people that are asking about the songs, I'm sharing a link. This is a link to Suno where we made those songs. They're really easy to make. They're fun to play with. If you use that link and go there, you can make your own songs just by putting in a couple words, and you say country music song about a crooked judge, and it will write the song. So you can use that link if you like. If you do use that link, I think it will give me some free songs, but that's it. Hang on. Oh, we've got a spam call. 1 second. Hello? 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 Is anybody there? Hang up. They'll call back later. All right, we'll continue.
And he did start off at first, correct me if I'm wrong, but didn't he start off at first telling you that his mom is the one that put the shotgun and also a TV in her trailer?
Well, yes, he changed his story a couple of times. He tried to tell me that it wasn't his trailer, but then he clearly says on the video that my girlfriend must have moved him out of my house, and they were underneath the TV. So I was never clear on the relation to when they got there, how they got there, or what the TV had anything to do with.
But he did initially say that his mother went and put him in there, correct?
Yes.
Initially. Okay.
Yes.
And then I believe his story might have changed after you, I don't want to say threatened him with his mom, but after you made the comment about, you're not going to throw your mom under the bus, are you? This is a federal offense. And that's when he then changed his story. Am I correct on that?
Correct. I was calling out his falsehoods to let him know that by him pointing his finger at somebody else and trying to place the blame, he could actually get them in trouble.
I know fingerprints were not taken from the shotgun. However, could they have been taken from the shotgun?
From that shotgun there?
Yes.
It could have been submitted, but they wouldn't have got anything off of it because of the rust and the wear. There's based on my training experience, there's nowhere on there that latent prints would be able to hold.
Okay. And do you have any way through your examination to determine when that shotgun was last fired?
No, sir.
So it might not have been fired for 30 years for all we know. Is that correct?
Possible.
I just want to make sure the jury understands something. You were out there investigating this burglary initially. Is that correct?
I never went to the scene that day.
Okay. But I mean, wasn't the feds investigating the theft of the gold coins?
Yes, I was assisting the Smith County Sheriff's Office with that.
Right, sir. And my client was not involved or not charged with anything involving the gold coins, correct?
I don't know that.
Okay.
To be honest.
You don't know if he was or was not.
Correct.
Okay. He was cooperative with you, was he not? When
yes.
you were asking him about the gold coins.
Yes, sir.
Did his interview help you in any way locate the people that was responsible for stealing the gold coins?
Yes.
Okay.
So he was the good guy. The lawyer almost said my client was not involved in any way, and then he changed it. He's like, my client was not charged in any way.
Mr. Harwell, your witness.
The theft of the coins.
Thank you, Your Honor. Just real quick follow-up, Agent Petri. Mentioned earlier that without a firing pin, it's still a firearm. So kind of a follow-up question to that. Without a firing pin, would it still be a prohibited weapon?
Correct.
State passed the list, Your Honor.
Mr. Stephen?
No further questions.
Any objection to Agent Petri being finally excused?
Your Honor, state would ask that he be subject to recall, but no objection to just being within a phone call.
Okay, Agent Petri, so you're still officially ruled, discuss your testimony with anyone else, allow them to discuss their testimony with you, not required to stay in the courthouse, but subject to recall by both the state and that's your sentence. All right, does the state wish to call any additional witnesses?
No, Your Honor, state rests.
State rests evidence at this time?
Yes, sir.
Mr. Stevens? Would you like your opening statement at this time?
No opening statement, Your Honor.
So that's waived. Does the defense wish to call any witnesses?
Yes, Your Honor.
Who would you like to call?
Sheila Prater, Your Honor.
Sheila Prater?
Prater. Prater, yes, sir.
P-R-A.
P-R-A-T-E-R. I believe that's how it's spelled, Judge.
Close enough. Sheila Prater. Here she comes. The court was nice enough to cut out all the bits and bobs where nothing happens.
Prater, before you step in there, I'm going to ask you to raise your right hand. So the place you swear that the testimony that the court today will be the truth, the whole truth, and nothing but the truth. So thank you, ma'am. Once you're still up, as you in there, okay? That chair does move around, so you can adjust it. Just make sure I see that you have your cell phone. If you wouldn't mind just like getting penis have that. Let him have that so make sure it's really quiet.
Green-eyed cat. There's the link right there to the country version.
Adjust your chair so we can closer to the microphone.
Okay.
Prater, during your testimony to the court, speak up loudly and clearly so everyone can hear what you have to say. My court reporter here is taking down the record of what everyone's saying, okay?
Okay.
It's very important that you allow your attorneys to finish the questions before you give any answers, so we're not talking at the same time. It should be very difficult for her.
I need to hear
if during your testimony, either attorney objects, they stand up, so Your Honor, I object. Just stop testifying, the court will rule on that or let you know whether it is or not, okay? And then finally, if you hear an emergency vehicle or a loud truck, the attorney is going to stop asking questions. If that happens to your testimony, I want you to stop so that time can pass, so that we can all hear what you have to say. Okay? Mr. Stevens.
Judge, may we approach?
You may.
First thing that happens is defense approaches. We get a close-up of what looks to be, is that a half Windsor? Help me on the knot there. It's not symmetrical. Where's this trial? This is in Texas. This is near Tyler, Texas. Defendant is charged with owning a prohibited firearm as a felon. It's a left Windsor, right? It's a half W. I think I could safely say that if there weren't $440,000 worth of gold coins found in his car, we probably wouldn't be here today. Of stolen gold coins. That's probably the impetus behind this one, because they couldn't pin it.
Issue that must take out outside your residence. So I'm going to put you in recess. I'm not sure how so.
They couldn't pin it on him, and so they chased this
I'm going to say let's be in recess for 50 minutes. Back in the jury room no later than 3:55. Deputy Paul was checking on it. Remember to follow the instructions I've given you so far. Don't discuss this case with each other at any time. Okay? Let's all rise for the jury.
I like this judge. Very confident what he's doing. Not too verbose. And very, very thorough, though. Sent Miranda Rock via WeTransfer. Let me pull up WeTransfer.
Thank you, sir. Thank you, Joey. So to the side of the you still don't get dog.
Are you going to be seated? All right, let the record reflect that the jury has been excused, that this hearing is conducted outside their presence. The court has done so on the suggestion that some of the questions may implicate the Fifth Amendment rights of the witness, Ms. Prater. And is your name Sheila Prater?
Yes.
Is it S-H-E-I-L-A?
No, L-I-A.
L-I-A?
Yes.
Is it P-R-A-T-E-R?
Yes.
Thank you, ma'am. And so I think at this time what I would do is just allow you, Mr. Stevens, to just summarize what issues that you believe are going to be the subject of Ms. Prater's testimony that could implicate her Fifth Amendment rights.
Yes, Your Honor. I'll be asking her. We've heard testimony already that it's stated that my client put the shotgun in the travel trailer and that my client lives there. Her testimony is going to be that she is the one that put the shotgun there and that my client doesn't live there, that she did. With that being said, it's a prohibited weapon. And if she testifies that she put it there, then that could open herself up to liability. So that's my concern, Your Honor. And I did visit with Ms. Prater, and I did explain those, concerns with her. So that's a perimeter of kind of what I'm talking about.
We want immunity?
Any response from the state?
But Your Honor, I guess in light of that, of those facts, I don't know that it's necessarily relevant to the case at bar in light of the fact that it's a possession of the weapon as to who moved what or where, but rather the fact that he was aware and he's testified to the fact that he had them there.
Right. This is not a question about him. This is a question about her. Do you have a response to his questioning of her and whether or not she should have counsel? I just want to.
Well, she absolutely should if she's going to be admitting that she, in fact, was handling an illegal weapon.
So what's the statute of limitations for possessing a prohibited weapon?
Your Honor, I believe under the state it would be 3 years. I don't know what it would be federally, though.
We need to find that out. I think you have an ATF agent who's
Is he still around? We can find out real quick.
Perhaps you should step out and give him a call. I don't know what the statute of limitation is for.
I don't either.
For a federal allegation of prohibited weapon. If it's when did the Van Zandt County Sheriff's Office take possession of this weapon? On November 25th, 2020?
Yes, sir.
So here we are almost 4 years later. So if the statute of limitations has run, then there might not be any criminal responsibility.
That's true. It's run.
Now, that begs the question, doesn't mean that law enforcement couldn't make an allegation. It just means a prosecution can't be had. It doesn't mean that a law enforcement officer couldn't be standing outside the door waiting to arrest her. Just means that a prosecution wouldn't be successful because it wouldn't be timely. Right. You all agree?
Yes, sir.
Yes. Okay. So what I would like to do is I'm going to stand in recess for a few minutes. I would ask the state to contact Agent Petri and see if you can get a quick answer for the court and a reference to the CFR that or whatever, or USC, whatever the reference is. And get the court a quick answer on that, so I don't have to go research that. And then I will still consider whether or not to appoint her counsel. Yes, sir. All right, court's going to be in recess for 5 minutes.
And we're going to be back in just a second.
Do I stay here?
You can get up if you want to. Yeah, so
I can sit here.
You can sit here.
You can just chill, man.
Ain't no need to be moving.
You can sit outside.
It's cold out there.
Okay.
It's cold. It's cold.
Where you are.
Thank you.
We'll be back in just a second. Blink your eyes.
All right, we're back on the record. Cause number CR 21-98, State of Texas versus Reginald Hoyt Young.
My favorite part is just say no.
This is a hearing outside the presence of the jury. Due to the nature of the direct examination and potential cross-examination of this witness, Miss Sheila Prater, the court finds that her Fifth Amendment rights against self-incrimination could become an issue. And so the court has found Miss Prater to be indigent, and the court is going to appoint the Honorable Richard Schmidt to advise Miss Prater both prior to and during her testimony regarding her Fifth Amendment rights. The court tomorrow, after she has received the advice of counsel, will also admonish her as to her Fifth Amendment right. But unfortunately, Mr. Schmidt would not be available today on such late notice. It is 4 p.m. So I think it's best to recess for the day. So I'm going to tell the jury that we're going to come back in the morning at 9 a.m. Ms. Prater, I'm going to order you to come back at 8:30 in the morning. 8:30 in the morning. And there you will meet with Mr. Richard Schmidt, attorney.
Okay.
And he's going to talk to you about your testimony and any implications it could have regarding any potential arrest or prosecution that could stem from that. Okay. And so I don't want you to say anything at this time, but you'll meet with him in the morning and he will advise you and counsel you. Okay. And he'll be here during your testimony and can be here if you have any legal questions. Okay.
It's fine.
And so I believe you've given the contact information to my coordinator, Ms. Tabriam. Is that correct?
Yes.
Okay. And so I'm going to order you to come back at 8:30 and then we'll begin promptly at 9 a.m. Any issues on that matter from counsel?
No, sir.
Any other?
No, sir.
Any other issues we need to take up?
No, sir. Not that I'm aware of.
All right. So the defense has indicated that they believe that Ms. Prater will be the last defense witness. Is that correct?
That is correct, Your Honor.
Okay. All right. So Ms. Prater, I'm going to go ahead and
So we're going to
where you're at,
Okay.
jury in, and I'm just going to let the jury know that there's an issue that we're going to deal with and that we're going to resume tomorrow. And that's what we're going to do.
Okay.
I'm not gonna play that because he's already said it like 3 times what he's going to do. So we're going to jump straight to tomorrow, which is now going to be today. And here we go. She's back. Oh, judge wearing glasses. Looks good. Looks good. I like the look.
All right, we are on record in cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of the jury. Attorneys for the state, attorney for the defendant, and the defendant are present on the witness stand. At this time is Ms. Sheila Prater. Yesterday, it came to the court's attention that there would possibly be some questions asked by Mr. Stevens regarding potentially incriminating responses, depending on the response of Ms. Prater. And it was recommended by Mr. Stevens that the court consider whether or not Ms. Prater should be afforded the assistance of counsel. The court had reviewed her indigency and finds her to be indigent. The court has appointed the Honorable Richard Schmidt for the limited purpose of advising Ms. Prater regarding her questions or regarding the questions and her answers thereto in this trial. Mr. Schmidt, at this time, if you will just, without divulging attorney-client privilege, can you just assure the court of any admonishments or statements of representation that you've made to Ms. Prater so that the court is satisfied that she understands her rights and her Fifth Amendment constitutional right against self-incrimination?
Yes, sir. After a brief review of the indictment in this case and the applicable statutes, I informed Ms. Prater of the statute of limitations as far as state charges are concerned. Statute of limitations pertaining to any federal charges that minor rights alleged conduct, no right to remain silent and against self-incrimination, depending on how that works as a witness, as well as the potential consequences for aggravated perjury, which is making a material misstatement under oath, and those potential state consequences, and her right to either waive those rights or to assert them during her testimony.
Thank you, Mr. Schmidt.
So she's informed.
And so, Ms. Prater, you understand that I swore you in to tell the truth yesterday, and so now you're under oath, just like you were yesterday. You understand that?
Yes.
And you've had the opportunity to talk with Mr. Schmidt, who the court has appointed as your attorney, correct?
Yes.
Do you understand that you have a right against self-incrimination?
Yes.
Do you understand that any questions asked by either the defense, through Mr. Stevens, or through the state, through either their prosecuting attorneys, that if that question has a tendency to potentially incriminate you regarding the response, you understand that you have a constitutional right to not answer that?
Yes.
And are you comfortable with what your discussions with Mr. Schmidt have been regarding what your rights are and the potential criminal consequences should you waive any of those rights or make any kind of statements that is incriminating to you?
Yes, thank you.
Okay. And so I'm going to go forward and I'm going to allow Mr. Stevens to ask us questions. And when he's through asking you questions, you'll be passed over to the prosecutors and they'll be able to ask their questions. If during that time you feel like you need to speak with Mr. Schmidt regarding any answer that you may give to that question, what I would like for you to do is just turn and look at me and say, Judge, I'd like to speak with Mr. Schmidt.
Okay.
And then we'll pause briefly. We may not excuse the jury, but I may allow Mr. Schmidt to walk up here and be able to have a conversation with him. And he can advise you during your question.
Thank you.
Okay?
Yes.
Mr. Schmidt, any objection to that procedure?
No objection to that procedure, although I would remind you that if you can speak with me, do it before you ask the question.
Yes.
All right. Any issue from the defense?
No, sir.
Any issues from the state?
No, sir.
Okay, we ready to bring the jury in?
Yes.
All right. Let's all rise for the jury.
Okay, so we're going to do this. Apparently, she's going to answer questions. She's been informed of her Fifth Amendment right that protects her from requiring her to self-incriminate. She appears to be willing to go and take one for the team, so to speak. Mama coming in testifying for her boy that the gun was hers. That was her sawed-off shotgun, and she put it there. So the ramifications here, depending on the federal and the state statute of limitations, which I don't know what they are in this case, she may, as a result of this, be facing charges where her own testimony is used against her in court.
Hey, you may be seated.
And even that might not help her son. They might.
All right, good
both
morning,
need
ladies
time.
and gentlemen of the jury. I appreciate you being here on time this morning. We are back on record at cause number CR 21-98. The jury is present and seated in the courtroom, along with the attorneys for the state, attorney for the defendant, and the defendant. I believe, ladies and gentlemen, that when we left off yesterday, I told you that we had some legal issues I needed to accomplish. We were able to get those done in your absence. And so we're going to resume with the testimony of Ms. Sheila Prater this morning. And I believe, Mr. Stevens, you had Ms. Prater on direct examination. Is that correct?
Correct, Your Honor.
All right. You may proceed at this time.
Thank you, Your Honor. Please state your name for the record and spell your last name.
Sheila Diane Prater. Prater is Prater.
All righty. And ma'am, how do you know Mr. Young?
Ray is my son.
Okay. And do y'all live together?
No.
Did y'all live together back in November of 2020?
No.
Okay. Were you
So if the gun was found in his house.
back in November of 2020, do you recall where you were?
I was in Arizona.
Okay. And what was the purpose of being in Arizona?
I had my knees replaced and I had gone back to Arizona.
Okay.
For the doctor. And I was actually like living there. So.
Okay. And when you were not in Arizona, but when you're back here in Texas, where do you live?
Excuse me?
Where do you live in Texas here?
In Ben Wheeler.
Ben Wheeler.
Yes.
Okay. And what kind of building or structure do you live in?
I live in a travel trailer.
Travel trailer.
Yes.
Okay. And how long have you lived in that travel trailer?
I bought it about 8 years, probably longer than that now.
Okay.
In what? 2011, I think.
Okay. Does anybody live with you?
No.
You live by yourself?
Yes.
Do you have any animals or pets?
Me and my babies. I got fur babies.
Okay. And when you were out of town, was your son going over to your property, taking care of the animals and whatnot?
Yes.
Okay. As far as you know, was he staying on the property, living on the property?
Not that I knew of, no.
Okay. He had his own residence, did he not?
Yes.
Okay. Do you recall if that was in Athens or not?
It was in Athens.
Okay. Now, do you know somebody by the name of Larry Don?
Tommy Don.
Tommy Don, I apologize.
Yes, Tommy
You know
Don.
Tommy Don?
I do.
Okay. And how do you know Tommy Don?
Tommy Don is a neighborhood guy that he's a jack of all trades.
Okay.
So everybody knows Tommy Don.
Everybody knows.
Okay. And Tommy John was actually arrested around your property. Is that correct?
Correct.
Okay. And after Tommy Don was arrested, okay, he had some property that he was worried about being stolen from his residence. Is that correct?
Yes.
Okay. And what was some of the property that he was worried about?
He had a TV and he had a gun, antique gun.
Okay. Was that a shotgun? Do you remember if it was a shotgun?
Yes, it's a shotgun.
Okay. And did you take possession of those items to keep for him while he was locked up?
Yes, I did.
Did you go to his property and get those items, or did your son bring those items to you?
I went to the property and picked them up.
Okay. And do you know if after you picked up the property, what did you do with it?
The TV is in the living room behind the chair, and I put the gun in the freezer. The freezer in my travel trailer does not work, so I just stuck it up there.
Okay. And where was the freezer located within your residence?
It's in the travel trailer, but like I said, it does not work. It's like just on the west wall.
Okay, but it's inside the travel trailer.
Yes.
Okay. Did you ever ask your son to pick up the guns, handle the guns, bring them to you, or anything like that?
No.
Okay. And so you're telling this jury that you're the one that picked up the shotgun and the TV and took to your property.
That's what I'm saying.
Okay. And do you know any idea about how long you'd had that shotgun?
Tommy John was doing some work for me, and I think he started doing that around September.
Ma'am, would that be
September
of 2020?
Right. As best as I can remember, it was late August. I'm thinking it was late August, early September. And this incident happened in November.
Right.
So like, what, 3-4 months?
Okay.
Somewhere like that.
What kind of work was he doing on your property?
He was tearing down my grandparents' house.
Okay.
And so, you know.
And were you there when the police came to arrest him?
I was.
Okay. Did he ask you to get that property?
Your Honor, objection leading.
Sustained.
Did Tommy Don ask you to go get that property?
Objection leading.
Over.
Calls for hearsay.
It was the same question.
Yes,
he just said it faster. Oh my goodness.
You did not go get that property at the direction of your son, did you?
No.
Okay.
No.
Do you know if your son ever handled that shotgun or not?
Not that I know of.
Okay.
And that was funny. Says the exact same thing. He just tries to get it in faster before he can
I'll
object.
pass the witness, Your Honor.
Mr. Hernandez, your witness.
Thank you, Your Honor. Good morning, Ms. Prater.
Good morning.
Let's just start there. The question that counsel just asked you was if you knew if your son ever handled that gun. Is that the shotgun you're talking about?
Okay. I'm not exactly sure what you're asking me.
Okay, let me clarify. I appreciate you asking me to do that. You just answered the question, did your son ever handle that gun? And you said no. Which gun are you referring to?
We're talking about the gun that's in question, correct?
Well, that's what I want to know. Which gun are you referring to?
How many guns are we talking about? I'm confused. I apologize, but
let me ask you about the shotgun.
Okay, ask me about the shotgun.
Okay, the sawed-off shotgun.
Yes.
Okay. Counsel just asked you if you knew if he ever handled it, and you said, not that I know of.
No,
Is your answer now no, or is it not that you know of?
not, I cannot say what someone did, not that I know of.
Okay.
Yes, that's my answer.
So he could have handled that weapon, and you would not have been aware of that. True?
I can't see people when I'm not there, so
Exactly.
that's correct.
Okay. So if there had been testimony here where, well, let's back up. Do you see your son here in the courtroom today?
Yeah, I do.
Okay. And can you just tell the court where he's seated?
He's sitting right there.
All right. So you see him. That's Ray, I believe you spoke with. You mentioned Ray.
I call him Ray.
Okay, but he goes by Reginald. Is that his first name?
His first name is Reginald.
Okay.
Thank you, Samantha.
I call
Very
him
generous.
Ray.
Okay. So let's get into the piece about the weapon. You were confused as to which gun we were talking about.
Well,
how many guns did you have on that property?
Well, I mean, you're the one that said which gun. So, like, I'm trying to, like, is there any other gun that we're talking about that I don't know about? Because I only know about the one gun.
Your Honor, may I approach the witness?
You may.
Yes.
She's going to hold up the .22 rifle and say, is this the gun? Here we go. Because she might not know this. Is this a .22 rifle? Oh, no, it's a
Speaker, this has been identified as State's Exhibit 7. Do you recognize this weapon?
I ain't never seen that in my life.
Never seen it in your life. Okay. And if...
Whose is it?
Well, if your son testified that he shot this gun while living on your property, was he lying?
Sir, I don't know what gun. I don't even know anything about that gun.
You don't?
I'm sorry.
Okay. Well, if I were to tell you that there's been testimony that your son told law enforcement that he asked you, or he went out and picked up a sawed-off shotgun and the rifle and brought it back to your property, is that a lie?
Sir, I don't know anything about that gun.
Okay. So you don't know if he shot it or not?
Sir, I don't know. I don't have a clue. I don't know anything about that gun.
So he could have shot it then?
Sir, anything can happen. I don't know anything about that gun.
Okay.
Now, this gun I know about.
Can we talk about your property there, ma'am?
If you like.
Please.
She's mad.
How many mobile home or travel trailers are on that property?
2.
2?
Yes.
Okay. And how would you describe the one you live in?
It's a 5th wheel. Got a bedroom, kitchen, living room.
Okay. All right. And what about that second? Is it more of an RV or is it a
No,
trailer?
the other one was my mom's.
Okay.
So it was a double wide.
Okay. Double wide.
Yes.
And do you know Tommy Don's last name, ma'am?
I do not.
You don't. Okay.
I believe
Waddell?
just calls
Does that
him
sound
Tommy
familiar?
Don.
I don't know.
Okay. All right. So this morning you testified that you actually moved that sawed-off shotgun. If I may approach, Your Honor?
You may.
You testified that you moved this sawed-off shotgun
Yes, sir.
and placed it in
The freezer.
the freezer.
Yes, sir.
And where was that freezer located again?
In my RV.
In your RV. And
Yes.
you testified that that RV, that it was in the freezer and that freezer was inside your RV.
Yes.
Okay. All right. I'm showing you what's been marked as State's Exhibit 1. Do you recognize that, ma'am?
Yeah.
What is that?
This is refrigerator, and this was an outside freezer.
Outside freezer.
Yeah,
Okay. And where's that freezer located on your property?
it's in the back.
Okay. And it looks to be that there's a trailer or a mobile home behind it. What is that?
Yes,
Is that the one you lived in?
yes,
So there's a refrigerator to the right, and then the freezer is center on State's Exhibit 1. Is that correct?
right.
And you've testified that when you moved that sawed-off shotgun, you put it inside the freezer in your RV.
Yes.
And that freezer is not in your RV in State's Exhibit 1, is it?
No, it's not.
Okay. So
The judge is
if
boring
your
his eyes
son
into my soul.
had told law enforcement that he moved that shotgun and that rifle from an automobile and put the shotgun, the sawed-off shotgun, in that freezer, is he telling the truth or is he lying?
Sir, I don't know.
You weren't there all the time, 100% of the time.
No,
Fair.
I was not.
Okay. If I may approach you, Your Honor?
Yes, sir. You may.
Ms. Prater, I'm showing you now a photograph that's been identified as State's Exhibit 3.
Okay.
Do you recognize that?
Yes.
What is that?
Freezer?
That's the freezer.
Yeah.
How about State's Exhibit 4 and 5? What is that?
That's that gun you just showed me.
And where is that located?
It's on the bench
And where is that bench located?
in the house,
Which house?
in mine.
That's your house.
Yeah.
I have no further questions, Your Honor. Ask the witness.
Mr. Stevens, you're with us.
Yes, Your Honor. Ms. Prater, when you picked up the shotgun to put it at your property for safekeeping, did
Yes.
you know that it was an illegal, prohibited weapon?
Had no idea.
Have you ever shot a gun?
No.
Never shot a gun.
City
So-
girl.
So you're not familiar with firearms at all.
Not at all.
It's your testimony that you are the one that picked up the shotgun and put it in on your property, correct?
Yes.
Pass witness, Your Honor.
Mr. Hernandez.
Ms. Prater, you weren't home on November 25th, 2020, were you?
No, sir, I wasn't.
And where were you on that date?
I was in Phoenix.
Pardon me?
Phoenix, Arizona.
Phoenix, Arizona. Okay. When did that surgery take place?
Oh, I had several. So starting in 19 till 20.
Okay. But November 25th, you were in Phoenix.
Yes.
And your son, the defendant, was taking care of your property that day, was he not?
Yes.
Okay. And did you know who he was dating back then on November 25th, 2020?
Heather.
Heather. And to your knowledge, was Heather there that day as well?
I have no idea.
You don't know. Okay.
But if Ray was there, I would assume so, but I wasn't there, so I don't know.
Okay. So you weren't there, and I just showed you State's Exhibits 4 and 5 showing that rifle And it's inside your RV, is it not?
Yeah.
And you weren't in Phoenix, so you have no idea how that would have been put inside that
No.
RV. And it's your testimony that that shotgun was placed in the refrigerator inside your RV.
That's where I put it.
So the freezer that I showed you in State's Exhibit 4, that's not the one you're talking about, is it?
No, it's not.
So logically, it would make sense that somebody pulled it out of your refrigerator and put it outside in the freezer.
Logically speaking, I mean, hey, we can't go against logic. It didn't walk out there. So yeah, somebody had to take it.
Didn't walk out there.
No further questions, Your Honor. I pass the witness.
Mr. Stevens.
No further questions, Your Honor.
Somebody
Any
does not
objection
mean the
to
defendant.
Ms. Prater being finally excused?
No, Your Honor.
No, Your Honor.
All right, Ms. Prater, you're free to go. Watch your step. Ms. Prater, you're free to stay in the courtroom if you want to, or leave, whatever you want to do. Mr. Stevens, does the defense call any additional witnesses?
No, Your Honor, the defense will press it.
Defense does.
All right, here we go.
Any rebuttal by the state?
No, Your Honor. The state rests and closes.
Closes. Defense closed.
And close, Your Honor.
All right, thank you. All right, ladies and gentlemen, you have received all of the evidence in this case. However, you've not received the court's written instructions, nor have you received the closing arguments of counsel. So what I'm going to do is put you in a recess for about 30 minutes, give me an opportunity to speak with the attorneys, give them an opportunity to confer on what instructions they want to hear. And so it's going to take a little bit of time. I think 30 minutes will be sufficient. It's 9:45 approximately. So I'm going to ask that you just be back in the jury room no later than 10:15. All right. Remember, you're not to discuss the case with each other or anyone else. If anyone tries to talk amongst you all about the case or to talk to you about the case, you report it to the court immediately to the bailiff. Okay. All right. All rise for the jury.
Just saw this news story that a Wisconsin kayaker accused of faking his own drowning and fleeing the country is alive somewhere in Eastern Europe and has been talking to investigators. It's unclear if he'll return to his wife and 3 children. Wow.
All right. Are there any issues before we recess to do the charge conference?
No, sir.
Okay. All right. Give me just a few moments and let me print out the proposed charge that I have, and then we'll meet back in my chambers and kind of go over it together. Okay. All right. Court is in recess at this
I
time.
have a question. Do you want to send the evidence back, the guns, or do you want me to take a picture?
The guns have been made safe, correct?
They have been, Your Honor, yes.
Let me think about that. I'll tell you when.
The shotgun can't fire anyway. Go ahead and send it back. Okay. Judge, you can join us again? All right.
All right. We are back on record. Cause number CR 21-98, State of Texas versus Reginald Boyd Young II. This is a hearing outside the presence of the jury, attorneys for the state, attorney for the defendant are all present. The court has conducted its charge conference with counsel, giving them an opportunity to review the court's proposed jury instructions. On behalf of the state, are there any objections to the court's proposed jury instructions?
None from the state, Your Honor. Thank you.
Thank you, Mr. Hartwell. Mr. Stevens, on behalf of the defense, any
No
objections?
objections, Your Honor.
All right, there being no objections, then the court will submit the jury instructions to the jury. Any other issues before we bring the jury back in?
No, sir.
No, sir.
All right, then the court will grant each side 20 minutes for closing arguments. And I understand the state will be dividing theirs 6 minutes for opening and 14 for the closing. Okay. All right. All right, then let's all rise for the
Crazy case, that kayaker thing. Jury's coming in. He's in Uzbekistan. Yes, he's in Uzbekistan with his girlfriend, apparently, where he transferred a bunch of money there before he, faked his death. Red Pen, are you trying to share the song? Jury's coming in. Yes, we can see them. Let me give you the WeTransfer link.
Let me see it. All right, let the record reflect that the jury is now present and seated in the courtroom. All right, ladies and gentlemen, at this time, I'm going to read the charge of the court containing the law applicable to this case and continuing to discharge your responsibility as jurors. You will continue to observe all the instructions that have previously been given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, the parties, the attorneys, and myself. If it should be found that you have disregarded any of these instructions, it will be jury misconduct and it may require another trial by another jury. If any of you observe one or more of your number violating any of these instructions, you shall immediately warn the violator and caution him or her not to do so again. Please listen carefully as I read the charge to you. And a copy has been provided to you for your reference. Jury instructions. Members of the jury. The defendant, Reginald Hoyt Young II, is accused of the offense of possessing a prohibited weapon. You have received all the evidence and must now decide whether the defendant has been proved guilty of an offense. Both sides will soon present final arguments. Before they do, I must now give you the instructions that you have to follow in deciding whether the defendant has been proved guilty of an offense or not. You will have a written copy of these instructions to take with you and use during your deliberations. First, I will tell you about some general principles of law that must govern your decision of the case. Then I will tell you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles. Indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, indicted, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. Unless all jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. Jury as fact finder. As the jurors, you review the evidence and determine the facts and what they prove. You judge the credibility of the witnesses and what weight to give their testimony. In judging the facts and the credibility of the witnesses, you must apply the law provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by attorneys during the trial are not evidence. The questions asked by the attorneys are not evidence. Evidence consists of the testimony of the witnesses and materials admitted into evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. Admitted exhibits. You may examine exhibits if you wish. Only exhibits that were admitted into evidence may be given to you for examination. In order to inspect the weapons admitted into evidence, you must submit a request in writing to the court. Testimony. Certain testimony will be read back to you by the court reporter if you request. A request must follow these rules. The court will allow testimony to be read back to the jury only if the jury, in writing, signed by the foreperson, states that it is requesting that testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The verdict. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty means that the state's evidence does not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. Defendant's right to remain silent. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Specific law applicable to this case. Accusation. The state accuses the defendant of having committed the offense of possessing a prohibited weapon. Specifically, the accusation is that the defendant did intentionally or knowingly possess a short barrel firearm and Eastern Arms 16-gauge shotgun. Applicable law. A person commits an offense if the person intentionally or knowingly possesses a short barrel firearm. To prove that the defendant is guilty of possessing a short barrel firearm, the state must prove beyond a reasonable doubt 2 elements. The elements are that 1, the defendant possessed a short barrel firearm, and 2, the defendant did this intentionally or knowingly. The state must prove beyond a reasonable doubt the accusation of possessing a prohibited weapon. Definitions. Possession. Possession means actual care, custody, control, or management. Intentionally. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. Knowingly. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Firearm. A firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance or any device readily convertible to that use. Firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by this chapter, and that is an antique or curio firearm manufactured before 1899, or B, a replica of an antique or curio firearm manufactured before 1899,
So it's
but
be older
only
than
if the replica does
1899 to be
not
an
use
antique.
rimfire or centerfire ammunition. Short barrel firearm. Short barrel firearm means a rifle with a barrel length of less than 16 inches or a shotgun with a barrel length of less than 18 inches or any weapon made from a shotgun or rifle if, as altered, it has an overall length of less than 26 inches. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt two elements. The elements are that one, the defendant in Van Zandt County, Texas, on or about November 25th, 2020, possessed a short barrel firearm, and two, the defendant did this intentionally or knowingly. You must all agree on elements 1 and 2 listed above. If you all agree the state has proved beyond a reasonable doubt each of the two elements listed above, you must find the defendant guilty of possessing a prohibited weapon as charged in the indictment. If you all agree the state has failed to prove beyond a reasonable doubt elements 1 or 2 listed above, you must find the defendant not guilty of possessing a prohibited weapon as charged in the indictment. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1, you must not discuss this trial with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. 3, you must communicate with the court only in writing, signed by the foreperson and given to the court through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. 5, you must inform the court if anyone attempts to contact you about the case before you reach your verdict. 6, you have been permitted to take notes during the testimony in this case. In the event any of you took notes, you may rely on your notes during your deliberations. In your deliberations, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Your notes are not official transcripts. They are personal memory aids, just like the notes of the judge and the notes of the attorneys. Notes are valuable as a stimulant to your memory. On the other hand, you might make an error in observing, or you might make a mistake in recording what you have seen or heard. Therefore, you are not to use your notes as authority to persuade the fellow jurors of what the evidence was during trial. Your sole duty at this point is to determine whether the defendant has been proved guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Next page, verdict form. Not guilty. We, the jury, find the defendant, Reginald Hoyt Young II, not guilty of possessing a prohibited weapon as charged in the indictment. Or guilty, we, the jury, find the defendant, Reginald Hoyt Young II, guilty of possessing a prohibited weapon as charged in the indictment. The court's original instructions will be provided to you by the bailiff in this notebook here. Also within this notebook, you will find forms entitled Jury's Communication to the Court. This is how you would communicate to the court in writing. It requires you to write the case number, which are found, it's found on the court's instructions, date, time, and which communication, 1, 2, 3, etc. And it also must be signed by the presiding juror with a signature and also a printed name. And it should be complete, and it should be thorough and fully convey if there is a question or an issue. Okay. All right, at this time, the state will be permitted to give the first closing statement. Mr. Hernandez, are you doing that?
Yes, Your Honor.
All right, you may proceed, sir.
Thank you very much.
Do you need the podium, sir?
No, sir, I do not. Thank you. May it please the court, Mr. Stevens. Thank you very much, ladies and gentlemen, for your attention to this matter. This is the last time I'll get to address you directly, and then you'll be given the opportunity to go into deliberations, go through the evidence. I'd like to start off by pointing out in the instructions on page 5, possession. Possession means actual care, custody, control, or management. I'd like to point out possession for you. I'm now possessing it, caring for it. It's under my control, under my management. I'm still possessing it, right? That was 6 steps that it took. I knew it was there. Possession. That is an Eastern Arms 16 gauge shotgun. As ATF agent Petri testified, it's a rather old shotgun, but it's post 1890s. He says it's probably early 1900s. So the exceptions as a curio or as a relic don't apply. This is a prohibited weapon by all accounts and definitions and should not be in public. He told you the very reason for it, or at least one of the considerations, was it's something that can be used for a lot of people. Placed underneath a trench coat, placed inside a coat. There are reasons for that. Also, got into specifics, the definition of that. You recall, it needs to be a barrel length less than 18 inches. Investigator Kelner testified that barrel length was 11 inches. That means somebody took off at least 7 inches off that barrel, making it an illegal weapon. And by all accounts, the full length, Investigator Kelner testified, was 19.5 inches. At a minimum, it should be 26. There are very good reasons in history why those things shouldn't be out. You've heard during the testimony that in conversation with Agent Petri and Investigator Kelner, admitted by his own words to going over to Mr. Waddell's property to get those 2 firearms, get the rifle, get the shotgun. That was possession, and he brought it back to that property. You also heard him admit in that conversation that he shot that rifle. Oh yeah, I shot the rifle, shot dogs. I did that. Does it stand to reason that he didn't know about that shotgun?
Shot dogs?
The phrase "in for a penny, in for a pound," right? If you're admitting to, yeah, I knew about the rifle, but didn't know about the shotgun. That's not logical. And if we go into that logic piece, when Ms. Prater testified that she is the one who went out and picked up that illegal weapon and a TV and brought it back to her home. And she placed it inside her home, in the freezer inside her home. But lo and behold, you've seen States Exhibits 4 and 5. Let me clarify that. States Exhibits 2 and 3. The interior of a freezer. Not working. But where was that freezer located? outside, not inside, as Ms. Grader testified. Reminds me of that story about if you're walking down a country road and you're noticing all the fence posts on your right side, you come upon a turtle popped up on top of that post. That turtle logically climbed itself up that wood, propped itself on that pole, or did somebody put it there?
Ah, the elusive climbing turtle. I've heard about these.
I submit to you, somebody put it there. That's what logic would tell you. Nothing magical happened. Gravity didn't fail to exist, and the turtle floated up and lightly tapped down on that post. Somebody put it there. Submit to you that President Young went and grabbed that shotgun, went and grabbed that rifle, and put them there. The other photograph showing the rifle is inside, in the living area of that trailer. States Exhibit 5 and 4. Ms. Prater readily testified and said, yes, that's the inside of my trailer. That's where I live. I've never seen that before. To her credit, she wasn't there on the 25th. I submit to you that those weapons were there for a while. She brought them over and mutilated them. By definition, that is a prohibited weapon. It's easy, I've pointed out to you in terms of the 11 inches to less than 26 inches. And by all accounts, are you going to believe what Mr. Young told you through that interview with Investigator Petri, Agent Petri and Investigator Kelner? He knew about the guns, he had fired the rifle. Or are we going to rely on Ms. Prater's testimony that she was responsible for moving those weapons over, but yet she doesn't know what happened on November 25th, 2020, Van Zandt County, state of Texas? Every bit of evidence points to the guilty word, Mr. Young, and I'd ask you to return that. Thank you.
I'd say there's room for
Thank you for returning this.
reasonable doubt.
Stevens.
I'd like the podium, Your Honor.
Bring in the podium. The podium. Butler Bailiff is rearranging the furniture. That looks great. Right about there is perfect. Thank you. Oh, a little bit that way. Oh, yep, right there. That's good.
May it please the court, counsel. Good morning, ladies and gentlemen. Again, I want to thank y'all for being here. Y'all are serving a very, very important function, important duty for society as it is. So I do want to thank each and one of y'all for being here. I want to point out that my client chose not to testify. It's his Fifth Amendment right, just like it's each of y'all's Fifth Amendment right to not testify if you were ever in his position. So you cannot hold that against him, ladies and gentlemen, that he did not testify. Let's don't get confused with the shotgun and the rifle. I believe the rifle's coming up to be kind of a scare tactic, so to speak. The issue is about the shotgun. It's not about the rifle. It doesn't matter if my client had fired the rifle or not. The issue is the shotgun. You know, we did hear from Ms. Prater. She had no reason to get up here and lie. I realize she's testifying to help her son. However, she has no reason to get up here and lie, ladies and gentlemen, because she has perhaps put herself in a position of compromise. I could very well file a case against Ms. Prater because of her testimony about stating that she is the one that handled the firearm, not her son. So she had a lot on the line when she got up and testified, ladies and gentlemen. And, you know, if y'all listen back to the recording from Agent Petri, if you recall, my client at the very beginning said he did not put the shotgun in the freezer, that his mom did. And then after they talk a little bit more, Petri basically, in a way, threatened my client. Hey, you better tell the truth, okay? And then at that time, he says, well, yeah, I did it. He didn't want to get his mom in trouble. That's obvious. You know, he loves his mom. He doesn't want his mom to get in trouble for anything. So, okay, I did it. That's what he said. And ladies and gentlemen, a lot's being made about this possession, as well as it should be, you know. And if you ladies and gentlemen would go look when y'all get the instructions again, look at where it says about possession, ladies and gentlemen. Care, custody, control, and management. I disagreed with the prosecutor when he grabbed the shotgun a while ago and then laid it back down. He said he still possessed it. I guess if I go touch it, then I'll possess it. Doesn't make sense, ladies and gentlemen. Okay. My client did not live at that location, period. His mom testified he lived in Athens. If my client had gone to get the shotgun and the TV, why would he have taken it to his mom's trailer? Why wouldn't he have taken it home to his house in Athens? Just doesn't make sense, ladies and gentlemen. And if you look at the shotgun, I mean, I realize under the definition of the law, it might be a prohibited weapon, but it's more of a relic than anything else. And if somebody grabbed it, it's not operable. You can't even fire the thing. Now, we've heard talk about, oh, you could put a firing pin in it. Yeah, if somebody knows what they're doing. But come on, it's not, it's more of a relic or an antique than anything else, ladies and gentlemen.
Barely missed the description of antique. It's a few years too new and
also, ladies and gentlemen, it kind of showed the fact that my client didn't live at that location. When the deputies came from Smith County, they were investigating a burglary that happened in Smith County. Some of their investigations led them to this location. When they get there, my client's asleep in his truck or his car. If that's his home, why wouldn't he be inside the mobile home or the travel trailer sleep? Why would he sleep in his vehicle? He would have been in the house. He didn't live there, ladies and gentlemen. He did not live there. His mom lived there. He was merely going over there to take care of the animals and whatnot when his mom was out of town. I'm sure mom doesn't know, but I'm sure he was going back and forth and basically on a daily basis taking care of the property.
I think the gold was in his vehicle. 10 gold coins, $440,000. Those must be massive gold coins.
Ladies and gentlemen, there is reasonable doubt in this case. Absolutely. There's reasonable doubt as to who put the shotgun in the freezer. Let's just say my client did put the shotgun in the freezer for a moment. Okay. He doesn't live there. He doesn't have care of control of it once he left that building.
Holding it is enough.
But he didn't put it there, ladies and gentlemen. His mom did it. And she put her neck on the line when she got up here and testified. And she testified to the truth, ladies and gentlemen. She did. You can look at her demeanor. She wasn't combative and, she was confused about the 22. She wasn't familiar with the 22. She's not familiar with any weapons for that matter. She never fired a gun, period. So, ladies and gentlemen, I'm going to ask you to find my client not guilty. Again, listen to the video. Listen for the reason why my client changed his story to the agent. Check that out. And again, ladies and gentlemen, my client did not have care, custody, control, or management of that weapon. Again, thank y'all for your close attention to this case, and I really do appreciate y'all being here.
So my client lied to protect his mom. Trust his mom, not my client. Judge Fleischer's court went off the rails this afternoon. We might go back and watch that before we break for the day.
Morning, ladies and gentlemen. So I want to start by just addressing a couple of things that Mr. Stevens brought up. The first being whether if he had grabbed the shotgun, whether he would be in possession of it too. And Under the law, yes. Actually, everybody who has the ability to control, manage, or take custody of that shotgun is in possession. Possession is not limited to one person. Multiple people can be in possession of the same thing. If any of you have spouses or significant others, own a car together, you're both in possession of the car because you both have the ability to manage it, control it, take custody of it. So I submit to you that, yeah, more than one person can be in possession of the same thing at the same time. Next, I want to talk about Ms. Prater's testimony. Mr. Hernandez asked several times, your testimony today is that you put the shotgun in the fridge inside the RV. Yes. Not in the freezer outside. No. So how did it get there? Somebody must have moved it. Not Ms. Prater. She testified to that. She told you unequivocally that she did not move that shotgun to the freezer. Logically, somebody had to have. And next I want to address Agent Petrie's. You heard his testimony that he had no interest in charging Ms. Prater. And you heard it during the conversation. Look, I know your mom's not a bad person, and I have no interest in charging her. I only want the truth. You heard his testimony, you heard him. He had no interest. Is he waiting out in the hallway to arrest her? I highly doubt it, even with sworn testimony. So I want to talk more about the evidence in the case. So on or about November 25th of 2020, we know that that was the date that Mr. Young was arrested for this offense. We don't know exactly what day he moved that shotgun around, but that's why the law allows for on or about. We know that he did it. Could have been on the 25th, could have been within a few days of the 25th. And we know that he was managing that property. The testimony today was that Mr. Young was taking care of the property. Well, what is taking care of if it's not managing? And he did, in fact, know that the shotgun was there. You heard in that conversation, he knew quite a bit about the shotgun. Told you that he had a cousin inspect the shotgun. So he knew it was there. You also heard in that conversation that, yeah, he did, in fact, go and pick up that shotgun. Once Agent Petri told him, look, I'm not after charging your mom, I just want the truth. Yeah, I went, I picked up the shotgun and the .22. You heard testimony that it was in Van Zandt County. That's undisputed here. It's in properties in Ben Wheeler. This is in Van Zandt County. Everybody agrees that Mr. Young is the person in question. There is no question as to who we're dealing with here. And so I want to go into a little bit more about the intentionally and knowingly. So you heard about the firing pin. You also heard just how easy it is to slip a firing pin in. You heard Agent Petri talk about just how many firing pins there are and how readily available they would be to get to make that shotgun fully operational in a matter of moments. You heard Agent Petri talk about why it's important for this law. He told you how the law came about with mobsters hiding them under trench coats, how they're easily one-handed weapons that can be hidden from anybody. And he also talked about the fact that the nature of a weapon doesn't change with or without a shot, with or without a firing pin. If that shotgun was pointed at you, I doubt that any of you would think, does that have a firing pin? Still a weapon. And that's why it doesn't matter whether the firing pin is in it or not. It is still a weapon by the very nature that it is designed to expel a projectile. You heard Agent Petri talk about the fact that it's not an antique. That fires a shotgun shell, a 16 gauge shotgun shell. He told you that a antique weapon is a black powder rifle, a muzzle loader. For those of you not familiar, that's a single shot.
Blunderbuss.
Like you see in Civil War or Revolutionary War, that long process of pouring powder down the barrel, putting the slug in. That's an antique weapon, not that.
Those are also modern weapons. You can buy brand new muzzle loaders.
And I want to talk a little bit about this 22 and why it's important. It's important because it corroborates everything else. Because you heard in the conversation, Mr. Young talked about, yeah, I fired the 22. If there were dogs getting into the trash, I'd have to shoot at them, have to get rid of varmints, shoot it just for fun. We live in the countryside. Hey, nobody can blame you. I mean, 22s are fun to plink with. Anybody who's ever gone out plinking with a 22 knows that, hey, quick way to blow off a little bit of stress, right?
No.
So why is it corroboration? Well, because he told you that the 22 and that sawed-off shotgun were together. So it's further indication that he did know about the sawed-off shotgun. When Agent Petri asks about his fingerprints, that's when he starts to hesitate, because you'll notice that in that conversation, Mr. Young was only concerned about that shotgun. From the very beginning, how can I be charged with a weapon without a firing pin? It's the only thing he was concerned about. So he equivocated. I don't think my fingerprints are going to be on that shotgun. I highly doubt they'd be on that shotgun. But he can't give a definite answer because he's hoping that they're not on the shotgun. But he can't say that they're not because he knows that he did, in fact, move that shotgun. That's why he couldn't give a definite answer. And yeah, you heard from Agent Petri, who told you that, yeah, with a gun like that, wood grain, some rust on it, there's nothing for a latent print to stick to. So yeah, we could not have pulled a fingerprint from that if we tried.
The stock, the handle of that gun, yeah, it would hold a fingerprint easily.
Next, I want to talk about a specific thing in the indictment, and that's that this is an Eastern Arms shotgun, a 16 gauge. Well, you've heard testimony that this isn't, in fact, a 16 gauge. You heard that in that conversation. And I want to point out to you, it's extremely faint, but Eastern Arms, you probably can't see it from there. I'd be surprised if you could. It is extremely faint, but Eastern Arms is written on the side of this firearm. So this is, in fact, an Eastern Arms 16 gauge shotgun. Ladies and gentlemen, during ver dire, Ms. Curry talked to you about the law in this case. Talked to you about firearms. Talked to you about whether, if you believe the evidence, whether you could convict. And each of you, by your answers, indicated that you could. If you believe this evidence, you indicated that you could convict. And then the judge puts you under oath to uphold the law. Ladies and gentlemen, what I'm asking you is to hold you to your oath. That if you believe this evidence, which is clear, that you convict Mr. Young of this offense. Because on or about November 25th, 2020, in Van Zandt County, Reginald Hoyt Young II did, in fact, possess a prohibited weapon. Thank you.
Dun, dun, dun.
Thank you, Mr. Robel.
Okay, jury is going to go
All right,
out.
ladies and gentlemen, at this time, you have received the court's charge, all of the evidence, and the closing argument of counsel. I'm going to hand to Deputy Martinez the official instructions of the court. He's going to deliver those to you. When you all gather into the jury room, it will be time to begin your deliberations, all right? So all rise for the jury.
I don't know when to push the button.
All right, we are on record, cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. Court has received a message that the jury has reached a verdict.
In what can only be said is a record 3-second deliberation time because of the magics of teleportation and time travel. The jury in the case of Texas v. Reginald Hoyt Young II has reached a verdict. This is a single charge where Reginald is charged with owning or being in possession of a prohibited weapon. The prohibited weapon in question is a 16 gauge, nearly antique, sawed-off shotgun. Not legal in the state of Texas, not legal under federal law, but in possession, according to the state. Where was it in possession? In his mom's freezer. The only issue at play is that his mom also says that she was the one in possession of the gun, that it was not Reginald and it was all her, and that he had nothing to do with it. Who will the jury believe? We'll find out here in just a moment.
Any reason we should bring the jury in at this time and receive the verdict?
Not from the center.
No reason. Okay. All right, let's all rise for the jury, and I'm going to have the alternate juror brought in as well.
We'll wait for the jury here. We see the jury filing into their positions. A lot of ladies on this jury. Well, actually, it looks like it's about even split. About 6 and 6.
All right, maybe so. Let the record reflect that the jury is now present and seated, along with attorneys for the state, attorney for the defendant, and the defendant. It is my understanding that the jury has reached a verdict. Who is the foreperson of the jury? You have the notebook in which, there we go. That's Deputy Martinez. I'm going to inspect the verdict, and then I'm going to return it to you for review.
Judge reviews the verdict. He has no dog in this fight. Just looking to see that whichever way they voted, it was filled out properly.
All right, court's returning this to the foreperson. Mr. Young, if you will please rise. Madam foreperson, if you will rise. If you will present the verdict of the jury to the defendant at this time.
We, the jury, find the defendant, Reginald Floyd Young II, guilty of possessing a prohibited weapon as charged in the indictment.
Thank you. You may be seated. Mr. Stevens, would you like to have the jury polled?
No, Your Honor.
All right. There being no request for the jury to be polled, the court finds that the verdict is complete and it is the unanimous verdict of the jury. All right, so the defendant having been found guilty, court will then proceed to the second phase of trial, the punishment phase, with the state like opening statements at this time.
Your Honor, may we approach this briefly?
You may.
It's going to be fairly short because this is the end here. Let's see what we have. It was we've got less than half an hour left of this one. And then we're going to jump in with Judge Fleischer because, oh my goodness, did he have a wild one. We saw the first half, but we get the second half once the lawyer shows up. And it's the girl in orange. You're going to love it. Let's just jump to sentencing. Let's skip forward a little bit. I'm okay with doing that. I mean, it's...
Not yet, Your Honor. We haven't started looking back to get the calculation started on it.
Okay. And so, Mr. Young, do you have an idea of what that might be?
I'm thinking roughly about 16 months, about 15 to 16 months over the past 4 years that I've been arrested on this prohibited weapons charge that I've spent incarcerated in jail.
Okay. And we can verify that. Let me ask you, Mr. Young, if your recollection is different than what the data shows, is that going to have a bearing on your decision today as to whether or not you accept their offer?
Well, I would like to know. I would like to know where it is because I mean, as far as I know, every time I've been arrested and I've been on the bond, I've been arrested every time I've been arrested, it's been for this charge, and the bond has been, every time I've been arrested, the bond has been dropped, and I've had to make bond on it again. So I would like to know. Yes, sir. Most definitely.
Okay. Prior to you entering into an agreement?
Yes.
What was their
if
offer?
I could.
Yes.
Yes.
Virginia Little, I have no idea who the
work.
Houston
All
judge
right.
is.
And let me hang on. I'm sorry, Mr. Hartwell. Let me ask one more question before I forget. And so, Mr. Young, you understand that if we verify your credit time and it is acceptable to you based on what time you actually spent in jail, if you change your election for the court to assess punishment and to accept this recommendation, this agreement between you and the state, you understand that you can't change your mind later once I let the jury go.
Yes.
You understand that there's a jury right behind that door and they're ready and willing to come out here and hear the evidence and give a verdict on that. In that range of punishment, to my understanding, potentially is from a minimum 2 years up to a maximum of 20 years based on an enhancement allegation that's been filed by the state. Understanding that if I accept your recommendation and your agreement, and I'm telling you that I would, okay, I'm not telling you that it's an if, I'm telling you that the agreement as you stated it, I would accept that. But once I inform the jury that they're free to, can't later change your mind and say, hey, I want a new jury or I want that same jury back. That would be over and done with. You do understand that?
I do understand it, Judge. Because one thing I understand is no matter what, I understand with the punishment phase, I know it can go anywhere from 2 to 20 years anyway. So for me to have new charges that I have to face anyway, it's better for me to go on and just take what I'm getting and get everything behind me to where I can get it finished and get on with my life, man, to try to do something different. You know what I'm saying?
I understand. And so to me, Mr. Young, it seems that you have intelligently thought through this offer, and the decision you're making is based on potential risks that you could be facing in the future.
Yes.
Okay. All right. So let's do this. Were you going to say something, Mr. Hartwell?
Just a quick question, Your Honor, to make sure that Ms. Abney is looking everywhere for jail credit. Was there any incarceration time outside Van Zandt County?
There was some in Henderson County. There was some, but I was arrested on the Van Zandt. I was arrested on the charge in Henderson County, and whenever I was arrested on the charge in Henderson County, that was also a part of my. Whenever I was arrested on the charge in Henderson County, that was also a part of my. The reason I was arrested was because I had the warrant out of Van Zandt County. So I was arrested in Henderson County for something else, and I was there, locked up there the whole time, and then. It's all part of it. So after I got done with my time in Henderson County, I was brought back to Van Zandt County. This was last year. I was brought back to Van Zandt County, and my bond was reset, and I had to bond out on this prohibited weapon thing again. But as far as it goes, whenever I got stopped in Henderson County last year, and I went to jail for the time that I was there, I was stopped and I was taken in to custody for my warrant that I had active out of Van Zandt County for prohibited weapon charge.
Okay, so I'll have Ms. Abney look at Henderson County as well as Van Zandt County for that.
Any other counties?
I had a little bit. I had a misdemeanor charge out of Smith County that I had to go to at the same time to sit out at the same time. But I was only there like a week, maybe a week and a half, 2 weeks that I was in Smith County. But I was in. I had for all three counties. I had a prohibited weapon here. I had a misdemeanor marijuana charge out of Smith County, and I had my. The new charge that I had in Henderson County that I had obtained whenever I had the warrant.
Do you believe when you were serving time in Smith County for that warrant or for that, you say misdemeanor marijuana?
Yes, they arraigned me whenever I was there. The day that they brought me there to Smith County, they arraigned the morning that I got there that Henderson County transported me. They arraigned me in Smith County on the prohibited weapons charge there.
So potentially you have credit time in Van Zandt, Henderson, and Smith?
Yes.
Okay.
All
right, then what we'll do is we'll stand in recess. I'll have Deputy Martinez let the jury know that we're dealing with some legal issues. And then if we can go ahead and try to get a back time verification for Mr. Young, then once we get that, if you'll go ahead and communicate that to Mr. Stevens. And then if that's going to be acceptable and appropriate and we feel like that is accurate, then we'll go on to the next step.
All right. Yes. Thanks.
Okay, so I'm going to back up. Recess. I'm going to back up just a tiny bit and see if we can see what happened right there, what the deal was. Jury goes out.
-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of the jury. Attorneys for the state, attorney for the defendant, and the defendant are present and seated.
Let's just want to hear what the deal is.
previously took a recess at the request of counsel before we began the punishment phase. It's my understanding that there's a proposition from counsel. Is that correct?
Yes, Your Honor. State has agreed to resolve the case for 20 years and to 1245, the new arrest charges from a couple weekends back on manufacture, delivery of controlled substance, an evading, and a forgery.
Okay. Mr. Stevens, any response?
What?
Yes, Your Honor, that is our agreement. And so with that being said, at this time, we would withdraw our request for the jury to do punishment and ask them to be changed to the court to do punishment.
Okay, fun fact. Here we go.
Having entered into an agreement with the state of Texas, finds that the recommendation as to sentencing from the state and the defense is for upon the court, which it has already accepted the jury's finding of guilty on the charge of third-degree possession of possessing a prohibited weapon, finds that the range of punishment is not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court, taking judicial notice of all filings in cause number CR 2198, including the indictment, finds that an enhancement paragraph has been alleged in the indictment and alleging that Mr. Young, having been convicted of a prior felony once before, would enhance the range of punishment from that of a third-degree felony to that of a second-degree felony under the statute, oftentimes known as repeat felony offender. So, Mr. Young, I would ask you, you've reviewed the indictment with your attorney, Mr. Stevens, is that correct?
Yes.
And you've reviewed that enhancement paragraph wherein the state has alleged in the indictment that on or about June 20th, 2013, in cause number CR 09-493 in the 294th Judicial District Court of Van Zandt County, that is this court, that you were convicted of the felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. According to that accusation, is that accusation true or not true?
That's true.
That is true. And Mr. Young, has anybody threatened, forced, or pressured you to plead true to that enhancement?
No, they haven't.
All right. Court does accept the defendant's plea of true.
So they're wrapping in a
Court
charge
finds
for
that
possession
Mr. Young
or
is
manufacture.
Enhanced up to a second-degree felony range of punishment, not less than 2 years or more than 20 years. Court finds that enhancement paragraph to be true. Court finds that the recommended sentence and the agreed sentence recommendation from both the state of Texas and the defendant in this case is for Mr. Young to be confined for a period of 20 years in the Texas Department of Criminal Justice Institutional Division, with court costs of $290, reimbursement fees of $255, and jail time credit of 329 days. The court hereby follows the agreement and the recommendation, and the court assesses punishment at confinement in the Texas Department of Criminal Justice for a period of 20 years, orders court costs and reimbursement fees, and awards Mr. Young his jail time credit for the time that he has spent in jail on this cause. Mr. Hartwell, I believe that you said that there was also some disposition letters that you are submitting to the court at this time to show that some other allegations in which Mr. Young has been accused but not officially charged by indictment or information. Is that correct?
Yes, Your Honor. State wanted those disposition letters to be part of this record.
All right. The court finds that 3 disposition letters from the Van Zandt County Criminal District Attorney's Office have been submitted. The court finds that the state is asking the court to take into consideration and to dismiss and prevent Mr. Young from being prosecuted on forward. It is a manufactured delivery of a controlled substance greater than or equal to 4 grams, less than 200 grams.
That's a big one.
Date of offense on or about October 26, 2024. The court takes that into consideration. Agency case number 24-29782 of the Van Zandt County Sheriff's Office, prosecution number DA 2024-1102. Court also takes into consideration an evading arrest or detention with a vehicle or watercraft, a third-degree felony, on or about, date of offense on or about October 26, 2024. Van Zandt County Sheriff's Office number 24-29-29782. DA cause number DA 2024-1103. The court takes that offense into consideration and bars prosecution pursuant to this sentence. Court also takes into consideration under section 1245 with the sentence in this cause a forgery of a financial instrument, date of offense alleged on or about October 26, 2024. Van Zandt County Sheriff's Office, agency case number 20868. DA prosecution number DA 2024-1104. Court takes that into consideration at this time too.
All right, that's where we're going to end it right there. Let me explain what just happened. The jury found him guilty. The jury was supposed to listen to testimony and then decide the punishment, and the range of punishment was 2 to 20 years because of his repeat offender status. Normally it's 2 to 10 years for that particular crime, but it doubles with repeat offender. Instead of letting the jury decide, and they could have come back anywhere in that range, 2 to 20, he accepted an offer from the prosecution of a 20-year sentence, which was the maximum the jury could find, if the state also dropped 3 pending charges he has. One for possession or manufacture of controlled substance, 4 grams to 200 grams. That's big. It could be a lot of drugs. I don't know what the penalties are in those cases, but the way he negotiated this, there is nothing hanging over him now other than his 20-year sentence. And once that's done, he might get time served. He gets time served counted against it, which is going to be a little over a year. So he's down to 19 years. But now he could do possibly, halfway along, 9 years or so, get out on good behavior. Maybe parole in 5. I don't know. It depends how full the jails are. But wow, I never thought I'd see someone accept a plea deal at the maximum. Why not risk it? Why not risk it for the biscuit with the jury and think maybe they'd feel bad because it was just a non-functioning firearm that your mom put in the freezer that you're going to jail for and give you just 2 years. But I guess the other charges could have locked him away for a long time as well. All right, we're going to play a little bit of music as we get ready to jump over to we're going to play Miranda Writes Rock, I think is what we're going to do. So just 1 second here. This is from Mathis. Mathis has created this one for your listening pleasure. And while we're doing that, I'm going to get over to Judge Fleischer's court because we have got to see what happens with the girl in the orange shirt.
In the United States, a Miranda warning is a type of notification customarily given by police to criminal suspects in police custody. You have the right to remain silent and refuse to answer questions. If you give up the right to remain silent, anything you say can and will be used against you in a court of law. You have the right to consult an attorney before speaking to the police, and to have an attorney present during questioning now or in the future. If you cannot afford an attorney, one will be appointed for you before any questioning if you wish. If you decide to answer questions now without an attorney present, you will still have the right to stop answering at any time until you talk to an attorney. Knowing and understanding your rights as I have explained them to you, are you willing to answer my questions without an attorney present? Just say no.
Just say no. I think that's going to be the title of that song, Matt. That's if I can name it. Just Say No. There we go. Now we're going to jump over to Judge Fleischer to see what happened. This is how we're going to end it today. This gets wild, guys. This is crazy. I have my goat ready. There she is, and back in orange. She had a bit of attitude when she came in.
Invoke my constitutional amendment rights as well as my civil and civil rights.
Computer remain silent. Yes, sir.
Is there a problem? I honestly feel threatened by this courtroom.
And this is not the circus.
I'm
this is not a playroom. This is a court.
I'm very coherent and competent.
No one says you were incompetent, but you have bond conditions that you're supposed to live up to. And we've given you so much as we've also given you a lawyer, and you're supposed to treat everyone here with respect. And when you don't, there's serious consequences.
Is there a thing for self-representation? I know that is a third option as well.
Of course you can represent yourself. You can do open heart surgery on yourself too?
Well, I ask for fair representation in a speedy trial.
No one here does anything to hurt anyone. The only thing that we're concerned about here is public safety and that everybody gets treated fairly and with respect. That includes
life and safety against Harris County.
I don't know what to tell you about there, but you need to take that with whoever you feel threatened by. But here,
Harris County.
Here, we need to protect everybody in Harris County.
Me and my children.
We've given you a lawyer. I want you to treat him with respect. And I want you to treat our clerks with respect, our bailiffs, and us. I'm not asking for much. The only condition I put on you now is to not go back to the location where you were allegedly trespassed from. They don't want you there. So that's why I'm telling you now, don't go back. That's the only condition that we have.
In regards to my housing, which is my documentation right here, that should be submitted into my file. My stuff is supposed to be terminated on the 30th of this month, which I had probable cause to actually go and speak with Gary Baxter in regards to my housing contract. I also emailed informal hearing before November the 1st and haven't got a response back. So I had every reason to be at Houston Housing Authority.
You may have had a right to be there, but at some point they're well within their right to say, look, we don't want you here anymore. You are creating a disturbance, so we would like you to leave.
Can y'all subpoena the cameras?
You can do whatever you want. You're going from here to here to here to here to here. Listen to what I'm saying and focus on this in the now. Don't start thinking of something in the future or something because you're not listening to what's happening now. You may have had a right to be there, but at some point you lost that because of the way you may have treated everyone and they didn't want you there anymore.
I'd like to file a hate crime against Harris County, the city of Houston.
Okay. You hear what I just said? What did I just say?
Oh, I can't go back to 2640 Fountain View Drive in regards to it being my property, but have an actual...
I believe so. It's the Houston Housing Authority.
Yeah, the Houston Housing Authority have an actual reasons to be there.
That's not to say you may send them an email. You could send them a fax. I don't know if that would include calling. As far as trespassing is concerned?
I can look into it, Judge. I'm not sure.
Yeah, I was wrongfully evicted.
They can have an issue if she calls over there. That I don't know.
The notice here that is kind of the subject of this incident does give her multiple options: email, mail, fax, phone, and she did send those emails.
I don't know now with them telling her they don't want her back. How does that play into?
They haven't asked for a no contact order and there's no specific person, I would say.
Exactly.
Because she
no response back from my email.
She still has not been, she lives in, she has housing assistance through the Houston Housing Authority judge. And it says her assistance will be terminated on the 30th. So, I mean, this is where she lives of this month. So she's still got a couple more days to try to resolve whether she gets to continue, having housing assistance.
The only other thing, it's what's your last name again?
Simmons-Ervin, Ervin.
You're very passive aggressive in the way you come off.
Well, I'm sorry, I'm a victim of Harris County.
That may be well.
And so are my children screaming.
That may be well right. But in life, you get more with honey than you do with vinegar. And when you go to these people and you act in such a manner that they think you may be threatening them, you're not going to get far.
It's retaliation.
Are you listening to what I'm saying? I'm trying to tell you, sometimes if you tuck your tail, you may get a lot more in life. I'll give you an example. I got pulled over months ago. I know I was in the right, but the officer came up and he goes, "Why did you stop? Why didn't you stop at that stop sign?" I know I stopped, may have been for a second or two. I told the officer, "Listen, Simmons," I told the officer, "Look, I'm sorry. It was an accident. I'm an idiot." He let me go. If I would have said to him, you a-hole, you're wrong. I didn't stop. I did what I was supposed to do. What do you think he would have done? He would have probably given me 5 tickets. But because I said, I'm sorry, I'm an idiot. It was stupid for me to do that.
Well, when you're facing reverse psychology,
you get more with honey.
And they try to provoke you.
So what? Who cares? Be the bigger person. You're still going to get more. That's life. That's maturity. And when you tuck your tail, sometimes you get so much more, even if you're in the right and they're in the wrong. Who gives a shit? Sometimes that's what you have to do.
I also understand the indirect language it is in the Harris County Handbook dated 2021. And anybody that threatens and harass me in it, I have every right to press charges.
Did you just hear anything that I just said?
I did. I understand. I won't be there, but I know that I had every right to be. So if I'm forced out on the streets,
you don't have every right to be.
It'd be because of the government.
You don't have every. I am telling you now, and I'm ordering you not to go back to this place.
I'm not going there, but I have every right to speak. So I guess I need to contact Washington or somebody in regards to my contract and things, because this is a government facility, and as it says your housing assistance will be terminated on 11/30/2024. I also have 2 different client numbers as well. One number is 582213 and another one is 251651. So I had every right in regards to speaking with Gary Baxter again, which is right here, Kenneth Coles, Gary Baxter. I also received an email to reinstate my housing, I don't know, from Gary Baxter in regards to all that. So I'm just confused, because if I'm forced out on the streets in regards to being homeless and they're trying to pass new laws, then just so hypothetically, of course, thrown back into Harris County against my will where I was held for 6 months, which is a violation of my constitutional and amendment rights, then it's retaliation. Also, I was told to surrender my inheritance in the direct language while I was being attempted murder by Harris County.
Have you speak to Corey about everything. Just remember, be nice. You get a lot more when you're nice than when you start raising your voice and yelling.
I am a traumatized victim. So if y'all could please work with me in regards to that, because I am a victim of Harris County. I do have a vow of Violence Against Women's Act. It is still in the residence portal and everything.
Simmons Ervin. If anyone ever treats you wrong,
she's like Simmons.
Just tell me, and I'll try to do what I can to help you out. In any way, any shape, form, fashion, whatever you know, I'll help you as much as I can. All you got to say is the word.
Also facing my children being, the child explicit cases.
Okay.
So let's just focus on just signing your
So
bond condition.
I'm going to have you sign the conditions. We'll have you stay with Corey. Just be nice. Hopefully you'll get your housing back if you're nice. That's it. All right? Please.
Simmons Urban. Simmons Urban. That's what I go by.
It's hyphenated. Simmons Irvin. Oh my.
Can you tell me the other contributions in the
Yeah, give me a second. Corey, do you have my cell phone? I'll text you real quick.
I'm like 99% sure
I don't.
the judge's entire text
Do you
was just
have it?
emojis. It was just emojis. Let me text you real quick. Emoji, 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 emoji.
Is it for her, Melissa? Is it for Miss Simmons?
Simmons Urban. No, other qualifications are in there, but I need to find.
Simmons Irving every single time.
Here's your copy.
Thank you.
There's your phone.
Hey.
That poor attorney. That poor attorney.
Yes.
Felicia,
Yes, Judge.
did you get the results in Miss Horton?
Ms. Horton? Yes, they were negative, Judge.
Okay, so we'll just
we'll just fade away from that. All right, that was wild. I don't think she comes back during that same session, but the poor attorney, all her rights, her civil and constitutional and amendment rights, and that she's filing a hate crime against Harris County. Whoa, that's a little much. And credit the judge. If I was the judge, I don't think I would have handled it as nicely as he did. He's like, look, you need help. The attorney will help you. We understand you want to sort out your issues with the housing authority, but the way you tried to do it, you can no longer do it in their office. You have to do it over email. Let your lawyer work with you. That's it. Just don't go back there. That's all you have to do. Just don't go back there, and you'll be good. But she was not good. Look at the time. It's almost 5:00, and it's Friday. We need to wrap things up here and get on the way. Is there anything I forgot to do today? There's probably a lot I forgot because I'm not remembering any of it. What does your shirt say on the back? It's got, it says Magellan Outdoors, and it has some red Solo cups, which are suitable for evidence collection. It's like American flag red Solo cups. Love it. Love the shirt. Let's see. We did watch the end of that one, Future. Are you saying they didn't get the 20 years? We watched the judge issue that. He took the deal. We watched that. Forgot a bunch I didn't remember either. It's been a great week, you guys. It's been a great week. Thank you very much. We've had a lot of fun. Thanks to all our amazing mods who made this week just fly by. I know they dealt with more than their share of trolls this week. Apparently, when I go live from my phone, it's like an invitation to trolls worldwide. And they handled that with style and flair. It was beautiful. Thank you very much. Tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again Monday morning. Oh, Sid comes in with 5 memberships, right at the end here as well. Monday morning, we're going to be live again with more greatness from court. Samantha Terry, thanks for the 10 gifted memberships. DSN, thank you for the super chat. Kim R, thanks for the 10 as well. You guys have a great weekend. You guys are amazing. Be good to each other. We'll see you on Monday.
I was kicked back, taking it easy.